because I couldn't find the HTTPS link. I could share it, but I couldn't find what the link was. I finally figured it out. I'm like, well, I got 5 years to create this whole thing.
You are here for an initial appearance after detention. The rules of criminal procedure require that you be brought before a judicial officer within 24 hours of your arrest. The purpose of the initial appearance is to have a judge list the charges against you, inform you of certain rights that you have, and to determine the conditions of your release. You should have already received a copy of these charges. The judge will review your paperwork to determine if there was probable cause to arrest you. If the judge finds probable cause, he or she will then determine if you qualify for bond and what the monetary and non-monetary conditions of your bond should be. If the judge does not have enough information to make a probable cause determination for your arrest, the state may be given additional time to amend the paperwork. You should also be aware of the following rights afforded to you by the Constitution. You are not required to say anything at this proceeding. Anything you say can be used against you. You have the right to communicate with counsel, family, or friends, and if necessary, you will be provided a reasonable means to do so. You have the right to counsel. If you have not already retained counsel and cannot afford counsel, the judge will appoint you a public defender. For the purposes of today's initial appearance proceedings, you may be able to briefly speak with a public defender regardless of whether the public defender is appointed for you. In order to have an attorney appointed by the court to represent you, you must be financially eligible, as determined by the court based on financial information you provide. Therefore, if you have not already done so, please complete, to the best of your knowledge, the financial affidavits provided by the correction officers. An application fee for the services of appointed counsel will be assessed. If you do not speak English or Spanish, please let a corrections officer know. When the judge is ready, she or he will begin calling your case by name. Please listen carefully for your name. When called, please approach the microphone as directed by the corrections officers. Thank you.
Usted se encuentra aquí para una audiencia o vista preliminaria, después de haber sido arrestado. Las leyes y estatutos criminales del estado de la Florida requieren que se celebre una vista preliminaria ante un oficial judicial dentro de un plazo de 24 horas después de su arresto. El propósito de esta vista preliminaria es para que el juez pronuncie los cargos contra usted, para que se les comunique a usted sus derechos procesales y para determinar las condiciones de su libertad o fianza. Ya usted debería haber recibido una copia de estas alegaciones o acusaciones por escrito. Ahora, el juez revisará la documentación en su caso para determinar si existe motivo fundado o causa probable para su arresto y detención. Si el juez determina que existe causa probable o motivo fundado, entonces decidirá si usted califica para que se le otorgue una fianza, tanto como cuáles serían las condiciones monetarias o no monetarias de dicha fianza. Si el juez no posee suficiente información para determinar si existe causa probable o motivo fundado para justificar el arresto, se le concederá a la Fiscalía tiempo adicional para modificar la documentación. También se les avisa que posee los siguientes derechos que se les otorgan por la Constitución. A usted no se le puede obligar a decir nada durante esta vista. Cualquier cosa que diga podrá ser utilizada en su contra como evidencia. Usted tiene el derecho de comunicarse con un abogado, pariente o amigo, y si es necesario, que se les proporcione los medios razonables y disponibles para hacerlo. Usted tiene el derecho a un abogado. Si todavía no ha encontrado o contratado un abogado y no tiene los recursos para hacerlos, entonces el juez le nombrará un defensor público. Para el propósito de la audiencia preliminaria de hoy, se le permitirá hablar brevemente con un abogado de la Oficina del Defensor Público, aun cuando no se le haya nombrado para representarle en todo el caso. Para poder recibir la designación de un abogado, primero debe calificar económicamente según lo determine el juez. Esto será basado en la información financiera que usted proporcione aquí. Por lo tanto, si no lo ha hecho todavía, de la mejor manera posible, por favor, llene el formulario de insolvencia económica que se le ha proporcionado por el oficial de correcciones. Se le impondrá un recargo o costo por los servicios del defensor público. Si usted no habla inglés, por favor, hágale saber al oficial de correcciones. Cuando esté listo, el juez comenzará el proceso llamando a cada una persona y caso por su nombre. Por favor, esté pendiente para pasar adelante cuando escuche su nombre y cuando escuche su nombre, haga el favor de acercarse al micrófono, tal como le indique el oficial de correcciones. Muchas gracias por su atención.
Good afternoon, everyone. Can you hear me okay out there?
Yes, Your Honor.
All right, thank you. Madam Assistant Public Defender, your name, please?
Christina Smith for the Public Defender, Your Honor.
Thanks, Ms. Smith. And for the state?
Jasmine Scarborough for the state.
And
And Officer Pat Hill on behalf of PTR.
thank you. All right, welcome, everyone. We're here for initial appearances, also known as IAs this afternoon. My role in IA is fairly limited. Basically, what I do is I take a look at the charging affidavit from the officers that have already effectuated your arrest to determine if there is probable cause. After that, we're going to talk about getting an attorney on board to represent you if you qualify for their services. After that discussion, I'm going to talk about conditions of bond, if any, that will satisfy the state and effectuate your release while the case is pending. I understand that many of you may disagree with what's in the charging affidavit. I completely understand that. It is very unlikely. I'm your trial judge, and that discussion, your disagreement with the facts of the case are really for another day between you and your attorney and your trial judge. If you are denied bond today, you may seek, in some situations, bond in front of your trial judges. Your attorneys will know how to get you in front of those respective judges. If we're addressing an out-of-county warrant, we're going to need to ship you back to that county so you can go in front of that judge and sort it out in front of them. I'm going to start off with our interpreter cases. We have 2 interpreter cases. Let me get the interpreter on board.
Your Honor, there are actually 4 cases.
Okay.
3 that require a Spanish interpreter and 1 that will require a Portuguese interpreter.
Okay, I just have Ms. De Silva, or I have Rayna Torres, and who else?
Mr. Hernandez and Mr. Jacarro, Your Honor. Both require the Spanish interpreter, and then Ms. De Silva is the Portuguese.
Let's see, Taderos. Do you have a Taderos on today's bucket?
He would be in the front. He is in out-of-county, I believe.
Yes, he's the Indian River County. He'll be the last out of county.
They were clipped together.
So it was De Silva's the Portuguese, Hernandez, Trigueros.
Okay, let's do our Spanish interpreter cases first, and then we'll try and get a Portuguese interpreter on board from Ms. De Silva.
Good afternoon, Your Honor. This is Rafael Barrera, State Certified Court Interpreter. I have been previously sworn.
Good afternoon, Mr. Barrera. We have 3 Spanish interpreter cases for you at initial appearances. The first one is Rayna Torres. Case number is 21 CF 3696.
President approaching, Your Honor.
Thank you.
My apologies, Your Honor. Could you kindly confirm the spelling of that last name, please?
Reina-Tornes. First name Arisleyder.
Thank you very much, Your Honor.
Good afternoon, sir.
Buenas tardes, caballero.
Buenas tardes.
Good afternoon.
Sir, you were arrested based on an allegation of driving while license suspended as a habitual traffic offender.
Señor, usted fue arrestado basado en una alegación de conducir con licencia suspendida a sabiendas como ofensor habitual.
I have read.
Por favor,
Excuse me, please?
que repita que no entendí.
Can you repeat that? I'm not understanding.
Of course.
Claro.
You were arrested based on an allegation of driving while license suspended. It's indicating as a habitual traffic offender, but it may be as a second or subsequent offender.
Usted fue arrestado basado en una alegación de conducir con licencia suspendida que indica que usted es un ofensor habitual, pero posiblemente simplemente puede ser como subsecuente, segunda o tercera ocasión.
Do you find probable cause for the allegation?
Determino que existe motivo fundado para la alegación.
I'm going to reduce your bond to $1,000.
Voy a reducirle su fianza a $1,000.
You may not drive without a valid driver's license.
No se le permitirá conducir a que no sea que tenga licencia válida.
Does he qualify?
I have not been receiving those like we usually do.
Okay.
So I'm not.
Ms. Smith, we're not receiving any of the affidavits. I don't know whether he qualifies or not.
Licenciada Slith, no hemos recibido los affidavits, no sabemos si reúne requisitos o no.
Yes, Your Honor. I have that he has 0 dependents and no job. He does not receive any SSI benefits or other benefits, does not have a bank account, own a car or a home.
Hold on just a second.
Su señoría, él no tiene dependientes, no tiene trabajo, no recibe beneficios de seguro social o ningún otro beneficio si no es dueño de casa.
Thanks for that information, Ms. Smith. I'm going to appoint the Office of the Public Defender to represent his interests.
Voy a asignar las oficinas del defensor público para que represente sus intereses.
And do we have any additional court dates?
On demand.
Próxima comparecencia cuando sea ordenado.
I've got no additional court dates to give you at this time. Thanks.
No tengo otras fechas adicionales en este momento.
David Hernandez, 21MM3323.
He's present and approaching, Your Honor.
Thanks.
Your Honor, if I may, the victim is here and present. I believe she was sent upstairs to check in, but she will be here.
Okay, let's skip over Mr. Hernandez's case. Eden Trigueros.
He's present and approaching, Your Honor.
Thank you. Good afternoon, sir.
Buenas tardes, caballero.
Buenas tardes.
Good afternoon.
Sir, you were arrested based on an allegation out of another county, that's Indian River County.
Señor, usted fue arrestado debido a una alegación que viene de otro condado, el condado de Indian River.
The allegation is that you failed to appear for a court hearing.
La alegación es que usted faltó de comparecer a una vista en el tribunal.
The judge there granted a bond in the amount of $2,000.
El juez ahí emitió una fianza de $2,000.
And I will appoint the Office of the Public. Well, you guys don't get appointed on the out-of-county stuff, do you?
No, Your Honor.
No se asigna el abogado defensor público en los casos fuera de condado.
We will notify Indian River County that you are here with us if you choose not to bond out.
Si usted decide no pagar la fianza, le vamos a avisar al condado de Indian River que usted aquí está presente con nosotros.
Sí la pagaré.
Ya, ve.
Okay, so you got a bond now, thanks.
Y usted tiene fianza. Muchas gracias. Your Honor, the interpreter could inquire, do you have a case number for this last defendant?
I do.
And I'm sorry, Judge, I also didn't quite get the name. We had a little bit of interference.
No problem. First name is E-D-I-N, last name Trigueros, T-R-I-G-U-E-R-O-S. And the number that I have on the warrant is 2020557.
Thank you, Your Honor.
Is the witness here on Mr. Hernandez's case?
Yes, Your Honor, Miss Amanda Diaz.
All right, thank you. David Hernandez. Mr. Interpreter, this is again 21MM3323.
Thank you, Your Honor.
Mr. Hernandez, good afternoon.
Buenas tardes, señor Hernández. Good afternoon.
Mr. Hernandez, you are accused of battery domestic violence related.
Señor, usted le acusan del cargo de agresión relacionado a un caso de violencia doméstica.
I have reviewed the charging affidavit and I do find probable cause.
He revisado el acta acusatoria y determino que existe motivo fundado.
I'm going to consider conditions of bond in your case.
Voy a considerar las condiciones de su fianza en este caso.
We do have a witness here, Ms. Diaz. Ms. Diaz, if you'll come to the podium, please.
Tenemos una testigo aquí presente, la señorita Díaz, si se puede acercar al podio.
Good afternoon, Ms. Diaz.
Buenas tardes, señorita Díaz.
Ms. Diaz, I am going to make some determinations as to conditions of bond. Ordinarily, they consider your wishes on whether you wish to have contact with Mr. Hernandez and whether you wish to have him return to the home on Kaiser.
Yo voy a hacer ciertas determinaciones hoy, señorita Díaz, sobre las condiciones de su fianza y van a tomar en consideración sus deseos, si usted desea contacto con el señor Hernández y si usted quiere que él regrese a la dirección que se encuentra en Kaiser.
Do Do you wish to give me any information about that decision?
¿Usted me quiere darme alguna información referente a esta decisión?
Yes, this morning I came to the courthouse. I filed for an injunction. I do not want any contact if he does return to the home to get his belongings. I ask it be with, a member of the sheriff department or police department.
Yo esta mañana me dirigí al edificio del tribunal y radiqué una orden de alejamiento. Yo no deseo tener contacto con él. Si él regresa a buscar sus pertenencias, debe ser acompañado por un oficial del orden público.
I also ask, because we have a 3-month-old child in common, that this moment is also taken to have that in account and custody be determined, and child support payments. I also ask that if he is granted visitation, it be supervised. And I do recommend the court he get some sort of anger management or therapy.
Y también quiero pedirle, porque tenemos un niño en común de 3 meses, que se determine algún tipo de custodia, que se determine pagos de manutención y si a él le dan algún tipo de derechos de visitas, que acuda a un caso de control de ira o algún tipo de terapia y que las visitas sean supervisadas.
All right, it's my understanding, who is Christy Lee Diaz?
She is my
Según yo entiendo, ¿quién es Christy Lee Díaz?
She is my mother and the owner of where we reside, of the home where we reside.
Ella es mi madre y es la dueña del sitio donde vivimos.
All right. It's my understanding, Ms. Diaz, that charges have not been formally brought with you being listed as a victim at this time.
Según yo entiendo, los cargos no han sido radicados de manera formal, indicándolo usted como víctima en este momento.
Your mother is listed as a victim in the case before me today.
Su madre es la que está indicada como víctima en el caso presente enfrente de mí en el día de hoy.
I do find probable cause for that allegation.
Determino que existe un motivo fundado para esa alegación.
Ms. Smith, do you have any questions for Ms. Amanda Diaz?
Licenciada Smith, ¿tiene usted alguna pregunta para la señorita Amanda Díaz?
No questions, Your Honor.
No tengo preguntas, su señoría.
Ms. Scarborough, any questions?
Yes, Your Honor. Has anything like this happened in the past, Ms. Diaz?
Señorita Díaz, ¿algo semejante ha sucedido anteriormente?
And are you currently in fear of the defendant?
¿Usted actualmente teme al acusado?
No further questions, Your Honor.
I'm sorry, Your Honor, the interpreter did not hear any responses. I'm not sure if the witness was verbally responsive.
She was faced away from the microphone. I think her responses were yes as to each question.
Thank you, Your Honor. Las respuestas de la testigo fueron que sí, ambas preguntas.
All right, thank you. Thank you for that testimony, ma'am.
Gracias por su testimonio, señorita.
As to the allegations of battery domestic violence related against Christy Lee Diaz, I have previously found probable cause.
Referente a los cargos de agresión, violencia doméstica contra Christy Lee Díaz, anteriormente había determinado yo que existía motivo fundado.
I will provisionally appoint the Office of the Public Defender to represent Mr. Hernandez.
Voy a asignar las oficinas del defensor público de manera provisional para que represente al señor Hernández.
The court is going to set bond in this case in the amount of $500 plus pretrial release conditions.
La fianza será programada en $500, además de añadirle las condiciones de libertad provisional.
Those conditions are that he is not to have any contact with Christy Lee Diaz.
No se le permitirá contacto con Christy Lee Díaz.
He is not to return to 3649 Kaiser Avenue.
No se le permitirá regresar al 3649 Kaiser Avenue.
He may return one time with law enforcement to collect any personal belongings.
Se le permitirá regresar una sola vez acompañado de un oficial del orden público para que recopile sus pertenencias personales.
That needs to be coordinated with the owner of the home with no sooner than 24 hours before he intends to go over there.
Y eso tiene que coordinarse con el dueño de la propiedad con 24 horas de anticipación.
Mr. Hernandez, you're on notice. I believe that a injunction may have been filed with regard to the other alleged victim, but that case has not been filed.
Quiero avisarle que es posible que haya sido radicada una orden de alejamiento referente a la otra víctima, pero eso todavía no está entablado formalmente.
Thank you. Thank you. That will conclude our initial appearance. That will conclude our initial appearance.
Concluimos la vista inicial.
Thank you.
Gracias. And Your Honor, does the court require any further assistance from the interpreter at this time?
I need a Creole interpreter. Do we do that through language line?
I'm not quite sure. Let my office know. We're a little short-staffed right now due to the holiday. I don't know if there's one available. If you call back and one is not available, then I guess you would have to use language line, Your Honor.
All right, thank you.
Your Honor,
You're-
Yes.
before the interpreter is excused, another inmate has notified me that he needs the services of a Spanish interpreter.
All right.
Mr. Ortiz?
And, Your Honor, we need a Portuguese, not a Creole.
My apologies, it's Portuguese. Mr. Interpreter, you still with us?
Yes, Your Honor, I'm here.
All right, thanks. I misspoke. It's not Creole, it's Portuguese.
Yeah, Your Honor, I sent a message to my office. Hopefully they'll answer me before we end this call. I can give you a better determination as to how to handle that.
Awesome, thanks for your help. We have Mr. Ortiz Pabon with us. The case number is 2021 CF 6770.
Thank you, Your Honor.
Good afternoon, Mr. Pabon.
Buenas tardes, señor Pavón. Good afternoon.
Is it Mr. Ortiz or Mr. Pabon?
¿Señor Ortiz o señor Pavón? Ortiz Pavón.
Mr. Ortiz Pabon, you are here with us based on a Orange County warrant.
Señor Ortiz Pavón, usted está aquí presente referente a una orden de arresto mediante el condado de Orange.
The case number is what I announced, 2021 CF 6770.
El número de caso que había denunciado, 21CF6770.
Ms. Scarborough, is this a VOP?
Licenciada Scarborough, este es el caso de incumplimiento de libertad vigilada.
Yes, Your Honor, it appears so.
Sí, parece que sí, su señoría.
There's an allegation that you have violated your probation in that case.
Se alega que usted ha incumplido alguna de las condiciones en su libertad vigilada en ese caso.
We'll let Orange County know, and we should have you over there pretty soon.
Le dejaremos saber al condado de Orange County y lo transportarán lo más pronto posible.
Unfortunately, the arrest has no bond.
Desafortunadamente, este arresto no tiene derecho a fianza.
You're going to remain on no bond until you can get in front of the judge over there.
No tendrá derecho a fianza hasta que usted no vuelva a presentarse al juez allá.
Thank you.
Gracias. Your Honor, I have been informed by my office that the Portuguese interpreter will have to be through language line.
All right, thank you.
You're welcome, Your Honor. Can
Thank
the
you for your
interpreter
help
be
today.
You're welcome, Your Honor. Have a good day.
You as well. All right, we're going to skip over Ms. De Silva's case. Do you know how to get language line on board?
There's information here. I can try it. I've never done it before, but it might take a minute.
All right. We're going to try and get the language line from Ms. De Silva, and then we'll address that case. James Russell.
He's present and approaching, Your Honor.
Thank you, Ms. Smith. Good afternoon, Mr. Russell.
Good afternoon, Your Honor.
Mr. Russell, you're with us based on an allegation out of another county. It looks like the warrant is 2021 CF 151000. The allegation is grand theft. It's out of Orange County. That judge has assigned a bond in the amount of $2,500. So you're bondable.
All right.
All right, thank you, sir.
You're welcome.
Brian Ibarra,
He's present and approaching, Your Honor.
thanks. Afternoon. Good afternoon, Mr. Ibarra.
How are you?
I'm fine, thank you. Mr. Ibarra, you are here with us based on an allegation of battery. That's a misdemeanor allegation, and the second is resisting an officer, it looks like without violence.
Yes, the resistance was caught in after I had gotten into the vehicle, and then he deported me and put me into another vehicle.
Okay,
I don't know if that was caught a fine.
I'm sure Ms. Smith would probably advise you not to talk about the facts of the case at this point. Anything you say is being recorded and could be used by the state in their efforts to prosecute you, so you might want to abide by that. I have read the affidavit. I do find probable cause, and I'm going to set a bond in each count. Bond in count 1 is going to be set in the amount of $500. Bond in count 2 is going to be set in the amount of $500. You're not allowed to have any contact with Luz Roman Cologne, and you can't go back to that hospital. You've probably been trespassed anyway. So no return to the scene where this occurred. I will appoint the Office of the Public Defender to represent your interest in this case.
When is my appointment with the public defender?
She's going to give you some contact information, and then you can call that number if you bond out and sit down with one of their
I'm not going to bond
attorneys.
out, so...
Okay, then they'll come out to see you.
Okay, thanks.
David Lowshaw.
He's president approaching, Your Honor.
And Your Honor, although he does qualify for direct PTR per the admin order, he does have substantial history that I would like for the court to hear before making their determination.
Is that out of our county or another county?
Our county.
Okay. Took a look and I couldn't, the name sounded familiar. Good afternoon, Mr. Lowshaw. Mr. Lowshaw, you are here with us in 21 MM 3325. The allegations are petty theft. I do find a probable cause for that allegation, and we'll be considering conditions of bond. It appears that pursuant to the admin order based on the offense, you qualify for pretrial release. Officer Hill, what information do you want me to have?
Yes, Your Honor. He does have 45 total prior arrests between 1988 and 2021, 17 which were felony charges, 23 of which were misdemeanor charges. His most recent was conviction of burglary to an occupied structure in August 2020, and grand petty theft conviction, burglary conviction in March of this year. He has been on probation and PTR multiple times.
Your Honor, if we may interject, he is indicating that that is his son and not him.
No, Your Honor, I am familiar with his son as well, and this is the defendant with the date of birth of May 10th, 1969. He has been on probation and PTR multiple times, and out of the times that he has been on, 5 of which were unsuccessful revocations.
Sir, I ain't got 17 felonies.
All right, so the 17 felonies she told me about, are you?
No, sir, I ain't got but 1 felony.
Okay. You know how many convictions you have, Mr. Lowshaw?
I know I ain't got 17 burglars. I mean, 17
Okay.
felonies.
I know we've met, Mr. Lowshaw. I recognize you.
I ain't got not that many felonies. 17, ain't no way.
Okay. And I remember the discussion about some confusion between you and your son who's got the same name. But pretrial release is run a report, and I'll let your attorney try and sort that out. It does not seem like pretrial release is appropriate based on the number of allegations. I'm going to set a bond in the case. It's going to be set in the amount of $2,500. You're not to return to the store where this occurred, and I will appoint the Office of the Public Defender. So you can't go back to the Walmart. You do have a bond that's based on the prior history that I'm being presented with. If that's somehow inaccurate, let the attorney know, and we can readdress that. Thank you, sir. Julissa Avadero.
She's present and approaching, Your Honor.
Thank you. Good afternoon, ma'am.
Good afternoon.
Will you pronounce your last name for me?
Avadero.
Okay, Avadero?
Avadero.
Avadero. Ma'am, you're here with us in 21 MM3326. It's an allegation of battery, a domestic violence related. I have read the charging affidavit and I do find probable cause for your arrest. Court is going to set your bond in the amount of $500 plus pretrial release conditions. The conditions of your pretrial release are that you are to have no contact with Matthew Robertson. I'm going to appoint the Office of the Public Defender. Ms. Smith, do you want to ask Ms. Avadero if they cohabitate?
Yes, Your Honor, they do cohabitate, and she will need a one-time return with law enforcement.
All right,
to her belongings.
they're to maintain separate residence while this gets sorted out. I will allow her to return one time with law enforcement to get some personal belongings while this gets sorted out. Thank you. Corey Williams, 21 CF 3697.
He is present and approaching, Your Honor.
Good afternoon, Mr. Williams.
Good afternoon.
Mr. Williams, you are here with us in 21 CF 3697. The allegations are battery, a misdemeanor allegation, and domestic battery by strangulation. I guess the battery is domestic violence related. I have read the charging affidavit, and based on the information, I do find probable cause. Court is going to set bond in both counts. Count one, it's going to be set in the amount of $500, and count two, it's going to be set in the amount of $1,000. It's going to have pretrial release conditions. The conditions are that until this gets sorted out or the court says it's okay, you are to have no contact with Ms. Simmons. And Ms. Smith, do you want, I'll appoint the Office of the Public Defender. Do you want to ask Mr. Williams if they live together?
Yes, Your Honor.
Thanks.
Your Honor, they do not cohabitate.
Okay. All right. They're to maintain separate residences. He's, I don't know if I announced, he's to have no contact with Ms. Simmons. And I appointed the Office of the Public Defender. So that'll do it, Mr. Williams. Thanks.
Thank you, Your Honor.
All right. The last case that I have on my docket is our language line case. I'm going to be off the record for just a minute while we try and sort that out.
Interpreter?
Can you hear me now, Your Honor?
Yes, I can now. Thank you very much.
Perfect.
If you would
No problem, Your
identify yourself and put on the record if you've been sworn in.
Yes, Your Honor. Alex Figueroa, State Certified Spanish Code Interpreter, already sworn.
Okay, thank you. Okay, again, like I said, if I forget anything or procedurally I skip over something unintentionally, do speak up. There's no ego involved. We want to do it right.
Yes, Your Honor, thank you.
Okay, we're checking something on our end, interpreter. Are we good there? Okay. All right. Sir, Are you Angel Claudin Bayless, something close to that?
Yes.
Okay. All right, sir. We do have an interpreter. Do you speak English?
Sí.
You do?
Yes.
Oh, okay.
Little bit.
All right. Because we're happy to have the interpreter, or if you're comfortable either way, that's fine. So
Sí.
would you comfortable?
Sí.
Okay. All right, sir, you have a battery, domestic violence, and is there anyone, I noticed, first off, let me just talk to the audience out here. There's probably about 6 or 7 people. Interpreter, could you speak to the audience and tell that, and say that if anyone, ask if anyone needs Spanish to raise their hand, because there may not be anybody. So would you find out about the audience?
Sure thing, Your Honor. A las personas que están en el público, ¿hay alguien que necesita el intérprete de español? Si es así, levanta la mano.
Okay, for the record, there's nobody indicating that they need an interpreter. Okay, and, all right. This is domestic violence. And is there anyone in the audience that is here for this particular case? And state,
Your Honor,
have any comments?
they will generally come up whenever they see or hear the name of the defendant we're here to see, as well as we do have security in the audience as well.
Okay,
Who knows who's here for who?
Okay, I'm sorry, I can't understand you.
Generally, the victims will come up when they see or hear whoever they're here to see. There is also a security officer in the gallery with the victims and witnesses that will also knows who they're here to see. And she will tell them to come up whenever they.
Good. All right. The this is domestic battery, and it's a misdemeanor level. And so the question is, I'm looking here at prior history. So, sir, are you understanding me?
Sí.
Okay, very good. All
Yes.
right. All right. Have you gone to prison? Did you go to prison on one of these priors?
No.
No.
All right. We would, now let me just check one thing. And you do have one child in common. At this point, without her being here to tell me how she feels about contact or anything of that sort, you're going to have no contact, which means don't see her. Also, you have a child together, and you're to have no contact with the child. Eventually, which really means a few weeks or a couple months, things may get back to a different situation. But at this point, while things are up in the air, I want you to have no contact with her, no contact with the child, and we'll go ahead and have $1,000 bond. And the reason for the bond being a little higher than I would normally do is because of your record. You have aggravated assault with a deadly weapon, robbery with a firearm. That's why I sort of thought in the prison. And so,
Your Honor, can he have a one-time return with law enforcement to have means from their residence?
yes. You do have, since you may have things at her place, now, public defender, do you, oh, I do appoint the public defender to represent you in this hearing. So, how do they do it today in terms of contacting law enforcement? Do they do that, or does your office do it?
No, Your Honor, they have to contact law
I
enforcement.
tell you, you can remain seated. One reason is because I want you to stay close to the microphone.
Yes. They contact law enforcement before they go over.
Okay.
Your Honor.
All right. Contact whatever agency has jurisdiction of that area, like could be the police, could be the sheriff. And so you can go back on one time while accompanied with law enforcement to get your clothing, any work tools, things of that sort. And we don't want you to, we pretty much have covered that. And so at this point, no alcohol or illegal drugs, no contact, I've explained to you. And that means also don't have any friends talk to her. Because if there's contact, they're going to think you're trying to intimidate her, and then they're going to just arrest you again for a new crime. No possession of firearms. And no new crime. If you get arrested for any new crime, including driving, it may revoke your bond, or bail. Okay. All right. Yes.
Here, since you ordered the one-time return with law enforcement, you're also ordering a separate residences?
Yes. Yes, thank you for clarifying that. I say no contact, that means you can't live together, you can't have any, I know you have a child together, but at this point, it's more important for you to stay out of trouble. And we'll work out all those other details. Anything else from state or defense?
No, Your Honor.
Thank you very much. Do I get? Okay, thank you.
And Your Honor, me dicho para que the case number for Mr. Coronado.
Number is 21 MM9144.
Thank you.
Okay, next is Juan Carlos Monte Vasquez, I believe. Is that you, sir? Yeah, he may need a translator.
Sí.
Yes.
Okay. And sir, this is a battery domestic violence. It is they've charged that you've been arrested for a misdemeanor. And did you know that misdemeanor is actually a contraction of two words? Misbehavior, misinformation. Mis means bad, and demeanor is conduct. So bad conduct is what misdemeanor means. And so that's why bad conduct, misdemeanor, bad, demeanor, conduct is different from a felony. And so, anyway, so you're charged with bad behavior, misdemeanor. Your history is virtually nothing. There is a grand theft some years past. Okay. we'll go ahead and do the bail at $500. No, since he doesn't have much of a past at all, we'll do it at $250. And no alcohol, illegal drugs, no contact with the alleged victim. That means you can't live with her, or no hostile, no contact, period. Don't speak to her, since she's not here to express her opinion about that subject. And that also includes no contact through other people or the internet. And if you have any children together, it's no contact with the children. We'll deal with that eventually. No firearms or ammunition. And you do have the right to go back one time with a law enforcement person, the police or the sheriff, having jurisdiction where the house may be, to get your clothing, tools, but it's a one-time to go with law enforcement, only with law enforcement. You understand what I just said?
Yes.
Okay. State defense, anybody have any comments?
Your Honor, DCF was called, so state would ask for the conviction to comply with any case plan put in place by DCF.
Okay. Since DCF has been called, I want you to cooperate with DCF, because they do have the best interest of the child in mind. That's what they're all about. And so cooperate with DCF. All right, thank you, sir.
And Your Honor, the case number for the interpreter?
Case number is 21MM9157.
Thank you.
Now, Leslie Jones. Okay. Interpreter, I want to thank you very much for your service. We couldn't function without you, and so thank you very much, and you're excused.
Not a problem, Your Honor. Thank you.
Okay, and you're Leslie Jones. Yes, sir. And this is an attempted felony murder. It would be a zero bond at this time.
Your Honor, this was a reset from over the weekend. The judge over the weekend did not find...
You can be seated so you're closer to the microphone, please.
Sorry, Your Honor, it's habit. The judge over the weekend did not find probable cause for the attempted felony murder, and state has no objection to that. However, I did obtain a new affidavit from the law enforcement officer. State would be asking for PC for an ag-back, great bodily harm with a firearm, which is an F1, which would allow Mr. Jones to have bond.
Did you say an M1?
An F1, Your Honor.
Oh, an F1.
Yes, ag-back, great bodily harm with a firearm. May I approach with the new affidavit?
Yes, please.
Can I speak?
And defense, did you get your copy of this? Have you looked at it? Have you had enough time to look at this?
Yes, Your Honor, I have.
You have any
I have no
comments?
objection to
Okay.
the, what, did you say, aggravated battery?
It'd be aggravated battery, great bodily harm with a firearm, which is an F1. It's Florida statute 784.045, sub 1, sub A.
And what, let's see, his history, let's see, we have, so there's a drug charge.
Yes, Your Honor, in regards to Mr. Jones's history, it appears he has mostly traffic violations, adulteresses, registration, things like that. His last criminal offense other than traffic was a 2010 robbery with a firearm, ag assault with a deadly weapon, and carrying a concealed. However, that was no prost in 2010. And then I believe he has had a 2009 cannabis that was also dropped.
So that was, and so we have at this, and this particular one, since it's an F1, you say he is entitled to a bond?
Yes, Your Honor, he is entitled to a bond. The alleged victim in the case did have to undergo surgery and was intubated due to the gunshot
Okay.
wound.
All right, well, since he has a prior gun-related charge, and then this is similar, his bond is at $75,000.
You're 75,000?
Yes, $75,000.
I would ask that you lower that, Your Honor. He has no convictions. That charge was dropped. And he has community ties. He's been in the area Orlando area for over a year. And my client is currently on Social Security disability. One of the arguments that was made on this weekend was that it was in self-defense. My client stands by that, and because of that, I am asking that you reduce the bond amount from $75,000, Your Honor.
Okay, I understood, State, maybe I misunderstood. I thought you said he had he had a gun charge. Was it an arrest, but not a withhold or not?
It was no prost, Your Honor. It was an ag assault with a deadly weapon, carrying a concealed, and robbery with a firearm from 2010. But it
was dropped?
It did end up being no prost.
Okay, all right then.
State has no objection, Your Honor, to a $50,000 bond, given that it is an F1 with a firearm.
Okay, all right, then we'll drop it to $50,000. Okay, and then obviously no alcohol or drugs, and no firearms or ammunition, and no additional crime. All right. Anything else from either party?
Yes, Your Honor. State would also ask for the condition of no contact with the victim or witness
Yes.
in the crime.
All right, no contact with the victim or the witnesses. The public defender will do that. And so let them do their job. They're excellent attorneys. Because if you contact them, it's going to appear that you're trying to intimidate witnesses. And so that's just another crime. And you're going to have this revoked, and it'll be $100,000 next time. And then any other crime. So stay away from everybody and stay out of trouble. Okay, thank you very much. Yes, thank you. Okay, next should be Daniel Maldonado. Are you Mr. Maldonado? No, sir. Okay, all right. And public defender can, Maldonado is in the hospital, and this is failure of defendant to appear. It'll be a zero bond, and you can always bring it up later. Is that okay?
Yes, I'll waive the appearance.
All right, so let's go ahead and just set everything at a zero bond, and appoint the public defender. Okay, and are you Tyrone Thompson?
Yes, sir.
Okay, Mr. Thompson, this is an aggravated battery. Oh, there's a lady in the well. Aggravated battery on a pregnant person. Yes, ma'am.
Your Honor, this was also a reset from the weekend. The judge did not find PC. I have provided a new affidavit to the PD. May I approach?
Yes, ma'am. Thank you. And defense, have you had time to read this, or do you need a few more minutes?
No, Your Honor, I have no arguments.
Okay, all right, without argument. Madam Clerk, can I give you this? Okay, and ma'am, would you please stand close to the microphone and speak up clearly, and to state your name and spell your last name?
My name is Rajane Eastland. My last name is spelled Esland.
Eastland, okay. Ms. Eastland, how do you know the defendant?
That's my husband.
And how long have you been married?
We've been married for a year.
1 year?
Yes.
Okay. Has he been violent towards you in the past?
No, well, he's never been violent to me. Am I able to speak on the situation a little bit or no?
Yes, ma'am. Then, just do it this way. I just want to know, has he been violent in the past? Is that a yes or no?
No.
Okay. Now you can tell me briefly about what happened this time.
Okay. Well, the officer, I'm not quite sure why the officer arrested him. There was really no reason for him to be arrested. He had my phone. That was really it. She put it as like aggravated battery. And a little bit before she pulled off, she told me that by him having my phone, that would have been considered aggravated battery.
Do me a favor and just take your mask off. Yeah, thank you.
I was stating that the officer that arrested him, she took him to jail for aggravated battery on me, but I explained to her several times that, you know, he didn't do anything to me.
Well, did he hit you?
He didn't hit me at all, and I explained that to him. She had like her body camera on as I explained everything to her. When she arrested him, we were both confused. So she told me that she was going to let him know that I did state that he did not put his hands on me at all. I'm not sure if she put that in the report or not.
Okay, were you or him drunk or high on anything?
No, I'm pregnant. I don't use anything, and neither was he. We were at my mother's house for Christmas.
Okay.
We didn't call. She was there for someone else, so I'm not even sure why she got involved with him.
Okay, let me state, did you have a comment?
Yes, Your Honor, if I may. It is an ag bat due to the victim being pregnant. That is the aggravating circumstances in this case. It is alleged within the affidavit that the victim, as well as the defendant, knew or should have known that she was approximately 4 to 5 months pregnant. It is alleged within the affidavit from the victim's testimony that she had her phone in her pocket. And he took the phone out of her pocket, which apparently was a deep pocket so that is the unconsensual touching within this case.
Okay. All right. At this point, we'll go ahead and do your bond at $100.
Your Honor, respectfully, there was a case with the same victim, same defendant, a BAT DV from April of 2021. It was dropped due to the victim being unwilling to prosecute. However, there have been prior incidences and prior arrests for BAT DV between this victim and this defendant.
But Your Honor, given the victim's testimony that she was not struck or hit, and given the facts in this case, I would ask that you stay the $100 bond.
Okay.
In this case.
All right, let me just, yeah, I do see some other things, but I think is based on what the lady said, I'll stay with the $100 bond. And you, so the, all right, we'll do the $100 bond, and no alcohol, no illegal drugs, no hostile contact. So, you know, no hostile contact means if she doesn't agree, you know, marriage is really a negotiations. And if you love somebody, you respect them, and you negotiate with them. You don't argue, you don't yell, you don't push. And so it just winds up in jail. Or if the cops come, they're going to arrest probably you. And so no hostile contact means no arguing, no screaming, no, don't say anything stupid. And just say, all right, well, we'll talk about it later. And so you can return to the home with that provision. Ma'am, do y'all have any firearms or weapons in the firearms in the house?
We don't own any firearms or weapons.
Okay. No firearms, no ammunition in the house. And in other words, don't go out and buy any. And do you understand what I've said?
Yes, sir.
So go home and there was something I wanted to say, but I'm trying to think how to, if I remember how to say it. I can't remember. But go ahead, go home and just relax. No arguing. If she doesn't agree, move on to another subject. All right, thank you very much.
Your Honor, he is out on bond for a possession of MDMA. However, state has not yet filed on that, so state's asking that you take no action at this time.
Okay. I think in this situation, we'll leave the bond as is. I'm not going to revoke it. Okay. Okay, thank you very much. Okay. Next is, let's see, are you Lawrence Corns?
The hospital, Your Honor.
Hospital. And we'll go ahead and reset this.
Can we do it 24 hours from release of the hospital, Your Honor?
Yeah, 24 hours from release from the hospital and returning to the jail. You know, this is actually it's not the jail. I know we say jail, but it's the Department of Corrections.
Yes, Your Honor.
And the first corrections actually began in England. In England, in about 1915, they had jails. And then the Methodist and people that wanted to help alcoholics, people that are illiterate, children, they said, give us these people and we will correct them and you won't see them, Judge, anymore. So the English judge said, oh, okay, you can have them, but I don't want to see them. And so that group of Methodist and Salvation Army and folks, they were so successful that England created, they changed the word jail to the Department of Corrections, and the corrections concept began in England in like 1918, 17, because it was so successful. And so then Europe adopted the idea of corrections, which was if they're an alcoholic, you try to treat the alcoholism. If they're illiterate, you try to get them to be able to read. Juveniles, you try to help them. And so then about 1930, Franklin Delano Roosevelt sent a committee to Europe to study corrections. And they said, you know, if we try to correct these people, we can reduce recidivism. And so they came back and the federal government changed the federal prisons to departments of correction, and then all of the states did. And so when I was in the military, I was the head of a small prison in the Air Force. And so I went to American University and studied corrections and criminology on the Air Force bill. And that's where I learned this. And my professor, Howard McGill, He said, don't ever let people say that corrections doesn't work, because it does work. It substantially reduces. There's about 20% of people that are just mean and nasty and you can't do anything with them. But 50 to 60, 70% of most people have underlying causes such as illiteracy, things of that sort. He said, don't let anybody say that corrections doesn't work. What happened is that the ultra conservative legislators have never funded it. And so it's not that it fails, it's just it's never been funded. And for instance, like they took the drug programs in prison, which were wonderful programs, and took them out of, in Florida, took them out of the prisons and put the money over in probation. And so now when we send a drug addict to prison, there's no drug programs. So if a guy's a burglar, but he's really a drug addict, you treat the drug addiction. And so, anyway, that's just the history of why this facility is called Orange County Department of Corrections, is because people sentenced here should receive training, job training, things of that sort, but it never gets funded properly. Anyway, back to what we're doing. Robert Doyle.
Yes, Your Honor.
Okay, Mr. Doyle. This is a battery, committed domestic battery by strangulation. I don't see anybody in the audience. And so, but then I see domestic violence, out of state, domestic violence, abduction, burglary, menacing by stalking, aggravated assault, domestic violence by threat, aggravated and felonious assault. State, do you see what I see?
Yes, Your Honor. Given the defendant's out-of-state history, as well as given the convictions of his out-of-state history, including at least 4 VOPs, showing an inability to comply with court order, as well as his history seems to be solely domestic battery-related history, including violating protection orders and domestic violence. State would be asking for a $7,500 bond, given that it is an F3 battery by strangulation. Given that it is out-of-state history, I do not know if it is the same victim. However, I do believe his history is significant.
Okay, anybody else? Okay, all right, based on your history, and this is a felony, which grade felony?
It's an F3, Your Honor.
F3. I tell you, with that history, we'll go ahead and do a $25,000 bond.
This is what he did.
And so,
It doesn't matter.
so a bond is set for both the current offense, but also considering someone's history. And considering his history, he's a dangerous person as far as I'm concerned. So a $25,000 bond is reasonable to protect society. Okay.
State would ask for a no contact, separate
Right.
residences.
No contact with the victim or the witness. And if he needs a one-time return to get his clothing and work tools, he can do that so long as he has law enforcement with him. Anything else, State?
Your Honor, State would also ask for no weapons, firearms, or ammunition.
Okay, no weapons, firearms, ammunitions, no alcohol or illegal drugs, no contact whatsoever other than to get his stuff with law enforcement. All right, thank you very much. Next, I see, Alicia, Hamad.
May I please say something about this whole case?
No, sir.
I was the victim in the case. I was assaulted. They took pictures of my head of me being assaulted from her attacking me with the cell phone.
Okay, all right, you've got a lawyer, and tell that to your lawyer, and then they can take it to a hearing. But as far as, talk to your lawyer. They wouldn't be able to tell you everything.
We don't have it.
Okay, next is Hoffa Fanfare. Did I say it right? I didn't. What's your name?
Happy.
Oh,
Happy.
Happy? Happy, and you're Fanfare?
Yes.
Okay, Happy. Okay. All right, Ms. Fanfare, this is neglect of a child, 1, 2, 3 counts, and conviction, throwing deadly missile, criminal mischief, throwing deadly missile, criminal mischief. State your thoughts about this situation.
Your Honor, state we just asked for a reasonable bond as she's otherwise entitled to it. I am looking up her criminal history now due to the victim seeming.
I can't quite hear you.
Your Honor, state would just ask for a reasonable bond given that the defendant is otherwise entitled to it on these charges. However, I am checking her CCIS due to her seeming confused when you read her criminal history. Yes, Your Honor. The throwing a deadly missile within a building and a criminal mischief was from 2013, and it was a withhold. It seems all her other history does seem to be traffic related.
Okay, DCF, I assume, is involved?
Yes, Your Honor. I do believe DCF was contacted.
Okay. All right, ma'am, you are to cooperate with DCF. And so this is an F3?
Yes, Your Honor.
Okay. All right. What's your suggestion on bond?
Your Honor, state has no objection to you staying the bonds that are currently set and treating 2 and 3 as subsidiaries.
Okay.
That's already on the affidavit.
All right. Then we'll do that. Madam Clerk, this will be $1,000 on count 1 and $150 on each of the other 2 counts.
Your Honor, state would ask for the conditions of no contact with witnesses, as well as no contact with the victims, which are the children in the case, as well as no alcohol or drugs, as there was an allegation of alcohol use.
All right.
You said to comply with DCF.
Yeah, just to comply with DCF.
I would just ask for the comply with DCF, Your Honor. I'm pretty sure they're going to put a case plan in place.
Right. I think DCF will most likely put the children with foster home at the present time. And so just comply with DCF. No alcohol, no illegal drugs, comply with DCF. And I'm going to trust DCF to do the right thing about the children.
Your Honor, in that event, the state would ask for no contact with the witness.
No contact with the victim, or witnesses, that is. And anything else, State?
No, Your Honor.
Okay, thank you very much. Okay, the next person is Alicia Ann Hamad, Hamad, Hamid.
I'm giving you the face sheet. That's
So
yours.
now what I do?
Okay, next should step up Alicia Hamad, or Hamad. How do you say your last name?
Ahmed.
Ahmed? Okay, Miss Hamad. This is aggravated assault, domestic violence, and it's been charged as a felony. And Madam, state your thoughts about this. Oh, I'm sorry. Before you give me that, sir, would you I want you to speak into the microphone and speak up.
Good morning. Good
Tell me
morning.
your name and spell your last name.
No problem. Good morning, Your Honor. My name is Yvonne, Y-V-A-N, Jagbir, J-A-G-B-I-R.
Okay. And you were involved in this incident?
Correct.
Okay. What is your relationship with the defendant?
My girlfriend for 6 years.
I couldn't hear the,
I'm
say
sorry.
again.
My girlfriend.
Take your microphone. I mean, yeah.
Oh,
Okay,
I'm sorry.
good.
My girlfriend for 6 years.
Oh, good friend, okay.
Girlfriend.
Oh, girlfriend.
Accent, I'm sorry. Girlfriend, yes.
Girlfriend.
Yes.
All right, do you have children together?
No, we don't. Not
Okay.
yet.
And has she been violent with you in the past?
No.
And tell me about this incident briefly.
Briefly, no problem. I think it was a minor misunderstanding that we had, and my lack of not paying attention made her react to not me paying attention, basically.
Okay, do you fear her?
No, I don't.
And do you live together?
Yes, we do.
Okay. If she returned to the home, is everything going to be peaceful?
Yes.
And we're not going to have the police involved again?
No.
Okay. All right. Ma'am, you heard that he is okay with you returning to the home, but are you comfortable doing that, or do you wish to, if I set your bail so you can get out of jail, do you wish to go somewhere else and live somewhere else?
No, I'm comfortable at home with him.
Okay, so you do want to go back and start living with him again?
Yes.
All right. Now you understand that the police are there to protect you and to protect people and to do their job. And so we don't want anybody getting hurt, getting killed, or being intimidated, threatened. We don't want him to threaten you. We don't want you to threaten him. We want you to be loving and kind to each other. Does that make sense?
I understand.
Can you do that?
Yes.
All right. And so you're returning. I just want to make sure. I know I've said this once already, but you're returning because you want to return?
Yes, I want to return.
And he's not forcing you in any way?
No, he's not.
Okay.
Your Honor, if I may, before you set bond. Ms. Hamad is here on an ag assault F3 and an ag bat F2.
An F2?
She's here on an F3 and an F2, Your Honor.
Okay, what's the F2 again?
It came in as a warrant. The F3 is the ag assault DV. The F2 is the ag bat DV.
Okay, here's an arrest warrant. Oh, yes, I see that.
Yes,
Can you explain?
Yes, Your Honor. The affidavit states that the victim has some medical vulnerabilities. He is in the United States from Trinidad due to having a traumatic incident that resulted in him having a skull fracture. The allegations are that the defendant entered the master bedroom where the defendant was sleeping and began to strike him on the head several times with a closed fist. After several strikes to the head, the victim left the bedroom, or the defendant left the bedroom. The defendant then re-entered the bedroom with a kitchen knife, searching for her car keys, asking the victim for her car keys, which he said he did not have. She then went to the closet with the knife still in her hand and began to destroy clothing within the closet. The victim approached her and she poked him on the forearm several times with the tip of the knife. And there are 2 cell phone videos indicating those 2 things regarding her entering the bedroom with a large kitchen knife and standing in the closet poking him with the knife. So the ag bat is the strikes to his skull where he has a skull fracture, and the ag assault and ag bat is her poking him with the kitchen knife.
Right,
And the ag assault is threatening him with the knife.
right, right.
I understand the victim's testimony that he does want contact. However, state would be asking for no contact at this time, which could be heard by the DV judge, which is Judge Shoemaker at this time, to modify that order, just with concern of the victim's safety.
Your Honor, the victim, he can call the police if anything like this.
Can you speak up just a little? Pull your microphone closer, yeah.
The victim has stated he wanted contact, he's not afraid, and he would be willing to call the police if anything like this occurred in the future. He does appear to be bigger than she is, and I do not think that in the future, him calling the police would be an issue in this particular instance.
Well,
And I think he wants to say
right.
something.
Looking at the affidavit, which is summarized by the state, yeah, something else is going on here that gives me concern. That's one of the reasons I asked several times a similar question. Something's wrong here. Did you say there's a DV court now that would address this, or is she entitled to a bond before she sees a DV court?
She is entitled to a bond, Your Honor, given the level of felonies that she is currently charged with. So this court, she should be receiving a bond today. However, this case is a DV case, and there is a DV court with a particular judge that does cover it. So usually that judge is more well-versed in the type of things that can be ordered due to seeing it.
Okay, I don't see any priors. Do you see priors that I don't see?
No, Your Honor.
Okay. Yeah, you know, sometimes people don't know what's in their best interest. They think they do. But even though he has said that he's willing to or agreeable to have you come back, this incident or incidents are scary. So, sir, I respect what you've said, but I don't agree with what you've said. And so I want no contact. So bond-wise, we'll go ahead and do, and that was an F3, right, State?
It's an F3 on the ag assaults and an F2 on the ag bat.
An F2, right.
Your Honor, can I?
No, you've said, I've given you your turn, and now it's for the attorneys and me to make a decision.
Your Honor, I do believe she qualifies for pretrial release.
No, I'm not going to do that. I will mitigate what I would normally do for an F2. So we'll have the aggravated assault, domestic violence will be 2,000, and then we'll do 2,000 on the other charge. So that's a total of $4,000. And then no contact. So no contact means no contact, no calling him, no going around the house, no, and if he calls you, you hang up. And so they don't have a child together, so there's no reason to contact each other. No alcohol or illegal drugs, no firearms, and no contact, period. And so at this point, based on these circumstances, it is not in your best interest, sir, or her best interest to have any contact with each other. when you start with knives and I think it was the defense that talked about his size. Well, it's not his size standing up that counts, it's his size laying down, because they're all equal laying down. Because she came and hit him in the head while he was sleeping and brought a butcher knife when he was sleeping. So horizontal, everybody's the same. All right, folks, thank
Honor,
you very much.
Can we have a one-time return with law enforcement to gather any belongings?
Yes, thank you for reminding me. A one-time return with law enforcement to secure her clothing and personal items and tools of her trade, if she has any. All right, thank you very much. Stay away from each other. It's not a healthy relationship from what I've heard. All right. Garrett, is it Garrett Mays? Oh, I'm sorry.
Text him up.
Okay, are you Garrett May?
Yeah, Garrett Mays.
I'm sorry?
Garrett Mays, yes.
Okay, yes, Mays, yes.
Yes,
All right, Mr. Mays, this is aggravated battery. We don't have anybody in this audience. And I do see, and this is a felony.
Yes, Your Honor, he does have prior felonies. However, it doesn't seem like he has prior violent felonies. They all seem to be drug or driving related for the most part, other than resisting without violence.
And this is charged as a felony, so F3?
It's an F2, Your Honor.
Oh, it's an F2, okay.
Agbat due to there being a weapon.
I say again?
It's an agbat due to there being a weapon.
Oh, okay, right. And that was a knife?
No, Your Honor, it was jumper cables.
Say jumper cables?
Hard jumper cables, Your Honor.
Okay, so I guess.
sure.
So, right, wait, you can talk to your attorney later on about the specifics of who did what to whom. Right, I remember this now. Well, looking at prior convictions, drugs, and tampering with some physical evidence, driving issue. Oh, did I forget something? Okay. So, thank you. Okay. tell you, my thought is, this is really an argument, and he had the jumper cables in his hands and hit the other person, swinging and hitting, and most of his priors are drug-related. See, how old are you?
I'm 58, sir. I was on drugs and I got help.
Say again?
I was on drugs and I got help. I've been clean for almost 15 years.
Really?
And this incident happened, I went to pick my son up.
Okay, yeah, let's not explain.
If you look, Your Honor, his last conviction was in 2011. He has not picked up any new drug offenses since then.
I got help, sir.
All right. Well, I understand. You know, sometimes when you lose your temper, whatever you have in your hand, you use.
I was jumping my truck off.
Okay. All right. All right. You still have a drug problem?
Oh, no, sir. I've been clean about 15 years.
Okay.
My son put me here, the guy that I love and do everything for.
Okay. All right. All right. I'll tell you what. They charge. I see the real world. They've charged this as a felony. I really don't think it should be pled out as a felony. I could see, because this is more of a bad temper and stupid things. You seem like a good guy. You had problems in the past.
But you wouldn't believe what I do for my son. I love this guy.
Well, okay, all right, I understand. I'll tell you what. I'm going to go ahead and put your bond at $200. That way you should be able to get out. I don't want you sitting in jail. I don't think you're a present threat. So it'll be $200 bond, and the other person, do you have any contact with that other person?
I do.
All right, no, we'll make it no hostile contact, because he was your friend, right?
Your Honor.
Yeah, my son.
Your son, that's what I thought,
I was picking
yeah.
him up from work. I get up 12 o'clock.
Okay, hold up, maybe the state has something that I need to know.
Your Honor, multiple things. One, state objects to a $200 bond. It is an F2. There was a weapon used, and he does have prior history of VOPs, giving him a high risk assessment score, showing an inability to comply with court orders.
But he hasn't done anything in, what, 10 years?
I believe his last conviction was 2011 for drug paraphernalia. And in regards to a no hostile, given that the victim is not here under Florida statutes and the admin order, since the victim is not here to testify whether or not he wants contact, this court cannot order a no hostile.
Okay, so
So
no
we'll be
contact.
asking for a no contact.
All right, so, all right, we'll do $200, no reason to be sitting in jail, and no contact. So when your son contacts you, you say, I can't talk to you. I want you to follow the rules. Rules are our friends. One of my favorite sayings is, rules are our friends, because they keep us out of trouble and they show us where the edge is. And if you see, the rule is you don't want to go past that edge because you're going to fall off and hit your fall. So rules are our friends. They help us. So I'm speaking as a friend to you. Stay away from your son. All it can do is get things confused. So when he calls you, you say, son, I love you, but I can't talk with you, and hang up. And I want you to respect me because I've shown you respect today, haven't I?
Yes, sir. Yes, you have.
Okay. So I respect that you're pretty much clean, I could put a high bond on you because of your history, but I've shown you respect because I think you deserve it, right?
Thank you, sir.
Okay, all right, thank you very much.
Can I have a one-time return with law enforcement to gather the belongings from the house?
Yeah, okay, y'all live together?
Yes.
Okay, then he may need to move, or you need to move or something. it doesn't matter to me who stays in the house.
Your Honor, in addition to that, separate residences and a one-time return, state would ask for no weapons.
Right, and no firearms, no ammunition, and you have to go, you can go back to the house with a deputy. But if he decides to move, then you can live at that house. Am I making myself clear?
Yes, Your Honor.
Okay, because sometimes, you know, your age, that house may be yours.
Yes, Your Honor.
All right, folks, thank you. I see Keith Sands. Mr. Sands?
Good morning, Your Honor.
Good morning. Okay, this is domestic violence battery, battery committing domestic violence by strangulation. We don't have any witness who's here to give the other side. And so, so this is an arrest warrant, and so they set these as no bond so that they're not released upon arrest, but we're supposed to deal with it.
Yes, Your Honor.
Okay. All right, state your thoughts about, obviously without the person here, to tell us the situation as to what they want. It should be a no contact. And your thoughts, see, last conviction, fraud, tampering with the utilities, and then there's cannabis, battery, domestic violence, twice before?
Yes, Your Honor.
Failed.
Looking at those cases, they do seem to be older. It looks like one is from 2003 from Brevard, and 2009 battery from Miami-Dade. There are other cases on here, such as solicitation to commit prostitution, cannabis, and some driving offenses. The state's main concern is that he does have at least 2 prior BAT DVs from different counties, as well as at least 1 prior VOP, showing an inability to comply with the orders. PTR notated that the DV history, however, is with a different victim. However, he is charged with an M1 BAT DV and a F3 battery by strangulation. So state would just ask for a reasonable bond as to both charges.
All right.
And Your Honor, I just ask that you take into consideration, he does have 0 failures to appear, and it appears that last, looks like VOP was in 2009.
All right.
The only other concern, Your Honor, is potentially community ties. The defendant did state that he intends to move back to Miami once he's released. And the purpose of bond is to secure his presence.
Yeah, you, as far as I'm concerned, basically Florida, we're all Floridians. I've lived here my whole life. I was actually raised in Miami when it used to be called Dade County. I think they call it, what do they call it, Miami-Dade now? All right, so, you know, you can go back to Dade County, but make sure you show up for any court hearings. Otherwise, you know, they just issue a warrant for your arrest, and the sheriff's office down there will pick you up.
Yes, sir. Your Honor, I currently live in Orange County at 4094 Dijon Drive, but they said it might be a no contact order, so I would be forced to go where I can live with either family or friends. I do like day labor work in the Central Florida area, so I'm always in and out of town working. So, but this was my home, and I'm aware of these egregious allegations, but I'm not guilty, Your Honor.
Okay.
I did not do this.
All right. What do you do for a living?
Construction.
Construction.
Blocks, bricks, concrete, stone laying.
Okay.
But it's not nothing with a big company here, so it's basically day labor.
Okay. The state, can you help me appreciate that the second count says domestic battery by strangulation?
I don't have access to the warrant, Your Honor.
Okay.
However, PC was already found by another judge.
Excuse me, Your Honor. This is supposed to be against my wife, which is Tabitha Jones, and my wife is clinically diagnosed schizophrenic and has multiple personalities. So when all of this stuff happened.
Don't talk about the facts.
Yeah, well, what you just said actually is more of a reason not to be together anymore. You know, there's no law that you have to be together. And so all right, so we'll do $1,000 bond. That's $100 to a bond company to get out
Your Honor,
of
there's
jail.
2 charges.
2 charges. Okay, and that's right.
And an F3.
Let's do count 1, Madam Clerk. Let's do count 1 as 500, and let's do count 2, which is a more serious one, at $1,000, and so then we do want no contact. That he is to have no contact. He's can return to the house with law enforcement to secure his personal items and tools, which I presume, based on your type of work, you have tools there.
Correct.
And so no alcohol, illegal drugs. And so no contact goes, so if she calls you, because I've seen lots of people arrested because the other person says, oh, I love you, and I want to see you, and I miss you, and no, and did I say no? Okay. And so it's the end, you know.
I understand, Your Honor.
And if she says, but I love you, you say, no, Judge McDonald said you don't love me anymore. And so
it's going to be hard for her to tell me that because I'm not answering the phone.
Good. So you blame it on me.
No contact, no text, no contact me, no contact.
Right. Absolutely. You strike me as an intelligent man, a tradesman, a smart guy. So let's just use this as an opportunity to separate.
Your Honor, my firearm was also confiscated. When the police arrested me, I sent them.
You can't get your firearm back until this case is over with.
Okay.
And so eventually you can get it back, but no firearms, no ammunition, no, did I say drugs or alcohol? Okay. Okay, well, yes. And yours, Keith Sands?
Yes.
Okay. Mr. Sands, take this as an opportunity to change your life. All right, thank you. Okay, Yvonne Smith. Good morning, Ms. Smith. This is aggravated battery with a deadly weapon, resisting an officer, disorderly conduct. I see some drugs and some drugs.
What kind of drugs?
It says cannabis. Oh, that's 1985.
Oh, I haven't been in trouble since then.
Okay. It,
Explain myself to you, Honor.
ma'am?
Can I explain myself to you?
Not really. It's really not appropriate. And I see a bunch of, okay. State, your thoughts.
Your Honor, she does have also another case as well. However, state would ask just for a reasonable bond as to all counts. It does appear her last conviction was in 1997 for a no valid driver's license. So state would just ask for reasonable bonds as to all counts. Count 1, the aggravated with a deadly weapon, is an F2. Then an F3, F3, M2. And then she does have the city ordinance of the failure to ID. State would just ask that you stay all the bonds as are currently set and set bond as to count 1.
What was the weapon?
It was a knife, Your Honor. It is alleged that the victim grabbed a knife and cut the defendant grabbed a knife and cut the victim's lower right arm. Blood spattered throughout the residence, and the victim was actively bleeding when law enforcement arrived on scene.
Mm-hmm. Well, I guess the
Your Honor, I am asking for a decrease in the bond amount. I would ask that you treat the remaining resisting disorderly as subsidiaries, and consider, if you're not going to reduce the battery on a law enforcement officer, I would ask that you consider setting a lower bond on the aggravated battery. My client is disabled. However, she has community ties. She's been in the Orlando area for over a year, 0 failures to appear, and that last conviction, besides the no valid, was in 1985.
all right. The aggravated battery with a deadly weapon would do it as $1,000, and then battery on law enforcement would leave at $2,500, and then resisting an officer with violence, $1,000. The disorderly conduct, $100. Failure to provide ID, $100. Okay, and any special instructions, anything else we need special?
Your Honor, state would just ask for the conditions of no contact,
Does
separate residences.
Does she need to return to that home or not?
Yes, Your Honor.
Okay, she can return to the home with law enforcement one time to gather her personal belongings and any tools.
Your Honor, is there no contact or no weapons?
Right, yes, no contact with the victim and no firearms, also no weapons, which is defined as a knife. So, okay, thank you very much, ma'am. Next is Julius Spires, S-P-I-R-E-S, Spires. Am I saying it right? All right, Mr. Spires. So you're on probation now?
Yes, I'm on probation. Yes, sir. Can I give you say a little thing, or wait till you finish?
Okay, we do have, this is a violation of probation. Now, this would be a no bond, and BOP court would deal with it?
Yes, Your Honor.
All right, no bond, and that really, I'm just saying that VOP court will be, you'll have a hearing shortly within a few days. How quickly do they have VOP hearings now? Okay. Couple of days, all right. It'll be taken up in VOP court.
Your Honor, he also has another warrant case of about DV, which is the underlying reason for the violation.
Okay, let me. All right, we have, okay, looks like battery, domestic violence.
Yes, Your Honor. He has a 2020 violation of a PTR condition on a domestic violence case, so failing to comply with court orders, and trespass and a VOP. That was the same victim as this instant case. He also has a 2020 misdemeanor, bat DV. It was the same victim in this case. There was a 2019 agbat with a deadly weapon, domestic battery by strangulation, criminal mischief. He only pled to the domestic battery by strangulation. 9499. That was, I believe, the same victim as in this case.
Okay.
There was also a 2016 felony, false imprisonment DV, battery DV. And I'm checking to see if that one is the same victim as well, Your Honor. That one was a different victim. The 2016 was a different victim.
Yeah, it wasn't filed on?
I'm sorry?
What do you say?
The two 2020 misdemeanor bat DVs and violating DV conditions were the same victim, as well as the 2019 bat DV, bat by strangulation was the same victim. However, his 2016 false imprisonment, battery DV was a different victim.
I believe that was an arrest. You guys didn't file on it.
We did not file on it. The victim was unwilling to prosecute in that case.
All right. We'll do the, we'll do a $2,000. No contact, no weapons, can return to the home with law enforcement only, and to get personal items and tools.
When will I be able to, for the hearing for the next, for the violation of probation? 'Cause I have an 8
Yeah, you'll see the VOP court in a couple of days.
Like, do it have a date, a certain date?
Just a couple of days, it's really pretty quick.
Okay.
Okay.
Yeah, 'cause my 8-year-old son out there with nobody, like, so.
Okay.
I have an 8-year-old son, man, excuse me. Me and my son are here from Mississippi. I have no family here at all. And my son is just out there right now, like with a person
Okay.
I know. He's just out there, man.
Okay. Next, we have Logan Williams.
Bullshit. When would they give me a date so I can go to court?
Okay, Mr. Williams, this is aggravated battery. And you have apparently he has charges in Osceola County, open charges. State, do you see that?
Yes, Your Honor. State would be asking that you revoke his out on bond due to being out on bond for a violent offense, and he picked up a new violent offense.
Right. The, So the bond that he's on in Osceola County, now, obviously, I am a circuit judge, and so, but procedurally, can I revoke an Osceola bond?
Yes, Your Honor, due to it being Ninth Judicial Circuit, you can do Osceola or Orange.
Okay. All right, so I'll revoke the Osceola bond that he's has outstanding. Now, that's, is that an F2? It says burglary, and he had an armed F2. It seems like it would be an F2.
It's an F1, Your Honor. An armed burg dwelling with a dangerous weapon is an F1 that's punishable by life.
Is that the,
Or that's
we are
not.
talking about Osceola County, right?
Yes, Your
Okay,
Honor.
that's what we're,
And then,
and then here is aggravated battery,
yes, Your Honor,
and so,
which is an F2.
yeah, it, so the aggravated battery, so here in orange, our aggravated battery is an F3.
The Agbat DV, Your Honor, that he's facing today in the 16162 case is an F2.
F3?
F2.
Oh, F2, okay. All right, since it's an F2 and considering his history, it's a $25,000 bond in Orange County based on his priors. Okay,
Your Honor,
and no weapons, no firearms, no contact with the victim or witnesses. Did someone start to say something?
Yes, Your Honor. I can't see it, but my client stated that his out on bond, they dropped it down to just a burglary. It's still with armed? They didn't drop it?
They was told in court. She said.
Well, I'm telling you, it's not dropped.
Also,
yet.
the person who finally tried.
Okay, next we should have Otis Gay, Mr. Gay. This is a battery, domestic violence. We have no witnesses, nobody in the audience. And we have Florida convictions, battery or shoplifting, possession with intent to sell, trespass, Florida arrest generally, burglary of an occupied dwelling, petty theft, battery, burglary, theft of a motor vehicle, and then we have battery, and this battery is, it's a misdemeanor battery.
Yes, Your Honor. It's also alleged within the affidavit, the victim told law enforcement that there was a battery that occurred 12/19, so approximately a week ago, with the same victim and same defendant where she was kicked and struck with a fist. So state would have you take that into account when considering bond.
All right, we'll go ahead and considering his history, we'll go ahead and do $5,000 bond, $5,000 bond, and no contact with the victim. He can return one time with law enforcement to get personal clothing and tools, no weapons or ammunition. All right, thank you. All right, next we have Christian Lopez Torres. And how do you say your last name?
Lopez Torres.
All right, very good. Violation of PTR conditions, that would be a zero bond and just go to VOP court.
Your Honor, you do have the discretion to set a bond on this case. The court could set no bond if you found there are no reasonable conditions to place on Mr. Lopez Torres that would secure his presence and his compliance with court orders. However, this time state's not requesting that you set no bond, state's requesting that you set a bond. However, given that it is a no contact order, it appears from Lake County. I don't have access to that original report. However, it does state that he was not supposed to have any contact with the victim and he was found in a Jeep with the victim. So state would ask that you set a bond on this. It looks like he has little to no criminal history, potentially some open charges of child neglect and battery. So state's asking for 10 grand, Your Honor.
Your Honor, I would ask for at least a $5,000 bond. My client's currently unemployed, and it does not appear he has any convictions on his record.
State would have no objection to a $5,000 bond if it came in conjunction with PTR, as he does otherwise qualify.
Okay, we'll do the 5,000 PTR.
Thank you, Your Honor.
State would ask for the condition of no contact.
Okay, no contact, and he can return to the premises one time with the law enforcement for clothing and personal items, work tools.
May I
All right,
have
thank
a
you.
word, please?
Say again?
May I have a word?
Not really. At this point, we've done.
And Your Honor, are you including maintain a separate residence as one of the conditions?
Yes, separate residence.
Your Honor, I've assumed when you've ordered one-time return, that came with a
Yes.
separate residence.
Yeah, but that's good to say. Yes, separate residence. Thank you. That's clarifying, and so that's very good. Thank you. Yes, I should say that because I think it's a good thing to say. So thank you. Okay, next we have Matthew Oliver. Mr. Oliver, good morning.
Good morning.
And this is a battery, domestic violence. Looking at his history and then looking at the facts, state your thoughts.
Your Honor, Mr. Oliver does have a fairly lengthy criminal history, including a conviction last month, as well as at least 7 prior failures to appear and prior VOPs, showing an inability to comply with court orders. I believe he is also a sex offender. And a lot of his history is violent history, including burglaries and batteries. So state would ask for a reasonable bond, taking all that into account, and given the allegations within the affidavit, or that the defendant punched the victim in the mouth with a closed fist and held her on the ground. So state would just ask that you set a reasonable bond, taking all that into account.
You know that that serious violations. How old are they? Can you tell?
Yes, Your Honor. He had the disorderly back in November 2021, a disorderly in February of 2021, possession of MDMA from 2019 that was dropped, paraphernalia and drugs from 2019 that was adjudication,
But for instance, like the burglary,
exposure to sexual organs 2019, drugs, driving. The sex offender violations, it appeared to be from Seminole in 2012. It was dropped. He also had a failure to update sex offender status from
Yeah.
Seminole in 2008. That was an adjudication.
the
A bad DV in 04.
right.
Burglary, petty theft, criminal mischief was 04. That was an adjudication.
Of what date did you say?
The burglary, felony petty theft, and criminal mischief was from Seminole County. It was an adjudication, and it was from 2004. So his most recent violations are mostly drug-related, Your Honor.
Okay. All right. This is a misdemeanor, but considering his history, we'll go ahead and do $1,000 bond. And no contact with the victim. And do you and the person involved in this, do you all live together?
No.
Okay, so let's just stay away from each other, so no contact, you don't live with each other, no weapons, firearms, no alcohol, no drugs, and anything else from anybody?
Your Honor, state would just ask for a no return.
Say again.
State would ask for a no return.
Oh, okay, no return to the place of the incident?
Yes, sir.
Okay, next is Larissa Riaz. Okay. Okay, Ms. Riaz, this is, I do see an outstanding, this is a pretrial diversion, so we'll go ahead and revoke pretrial diversion. And this was a disorderly conduct, that was the pretrial diversion. And we'll go ahead and put a $200 bond on that. And then this is a dating violence, and there's nobody here to speak on that. And I do notice that you have drug paraphernalia, the marijuana a couple of times. You know, we have, Orange County is really fortunate to have a really good public defender system and the state attorney's office. I think both offices are excellent. But we also have drug court, and you may have a drug addiction issue that you want to take advantage of the services that we have. And so you know, ought to talk maybe to your public defender, who I do appoint. Now, do you and the victim here live together?
No.
Okay, so there's no contact. Do you have a child together?
Yes.
Okay. You have custody of the child?
Yes.
Okay, has DCF taken the child temporarily?
No.
Okay, have they been called to your knowledge?
What I read on a piece of paper, yes.
Okay.
We have been contacted, Your Honor.
All right, so then as far as your child goes, I want you to follow whatever DCF says, because they're charged with protecting the child. And so you need to cooperate with them and try to fix whatever problem there's going on. So no contact with this other person. And do you have any personal items where he lives?
No, everything's at my house.
Okay, very good. All right, so you have separate residences, I take it from what you just said?
Yes.
Okay, excellent. So no contact. If you can't get along peacefully, you shouldn't even bother to be with each other, because you're just going to get in trouble. So, all right. So at this point, no drugs, alcohol, no weapons, and no contact with the alleged victim.
Your Honor, what was the bond amount?
Say again?
What was the bond amount?
Oh, I'm sorry.
It's an M1, Your Honor, so Steve would just be asking for 500.
It's an M1, so we'll go ahead and do $200.
Thank you, Your Honor.
Thank you.
Yes. Okay, and next we have Jacarro Robinson.
Yes, sir.
Yeah. Okay. Yeah, if you just speak up, it goes through it, so it works okay. But I understand why you pull it down, because you think it would be better. So, okay, well, we do have a battery, and I'm looking, you you're not out on anything. A victim request for confidentiality. Okay, and this is a misdemeanor. Okay, do you and what's the relationship between you and the victim?
My baby mom.
Okay, all right, at this point, do you and she live together?
Yes, sir. But I want to say the last month we haven't.
Okay, you separated.
Yes, sir.
All right, so let's have no contact with the victim or the child. So we can work on those things eventually. And do you have all of your stuff? You know, there's an old country song, and when I was doing domestic in Kissimmee, and I would drive to Kissimmee every day, I would always listen to the country western song station, and because it would remind me of domestic court. And this one song said, the toughest thing about breaking up is getting your stuff. And so, do you have all your stuff?
No, sir.
You need an order to go get it?
Yes, sir.
All right, so let's follow the country western song and let them get us stuff with the sheriff's deputy.
Thank you.
Okay. Well,
Your Honor, when setting bond, arguably the facts, this could be charged as a burgbat. The affidavit alleges that the defendant opened her car door, which the victim then closed back. He then opened the door again, hit the victim in the face with his fist while she was inside the vehicle, grabbed her keys out of the ignition, and grabbed her cell phone. The victim ran after him, and he then punched the victim in the face, which caused her to fall to the ground.
mm-hmm.
Arguably, this could be charged as a burgbat. I understand it's not currently charged that way today. However, if charged that way, it is a PBL. I understand that Mr. Robinson has no criminal history other than a 2019 driving offense. However, given the allegations within the affidavit, and given that there was a independent witness who corroborates that, state would be asking for a higher bond on the M1.
So were y'all together for you to see the child? Or why was the child and the two of you together?
He was with me for the holidays.
Okay.
She was coming to pick him up.
Okay. All right. And so did he come to your house?
Yes, sir.
Okay.
My grandma's actually.
Grandma's house?
Yes, sir.
Okay. You know, that sort of situation, you should let grandma do the exchange. I remember McDonald's got mad at me in Kissimmee because I was having too many people do the exchange at McDonald's. So they wrote to the chief judge and said, tell McDonald to not use McDonald's. And so, so really, you know, you seem like a smart guy. Have someone else there do the exchange, because the exchange is always, people will say stupid things and do stupid things.
That's how we've been doing it. Like this last month, since we've been separated, that's how we've been doing it.
All right. All right. Well, we'll go ahead and do the bond at $200 so you can get out. You don't have any real history, so I don't think you're going to be out there doing terrible things. This is just stupid stuff.
Thank you.
So we don't do stupid, right?
No, sir.
Okay, so no stupid stuff. So we'll have no hostile contact.
Your Honor, she's not here to testify. That would be against Florida statutes. State's asking for a no contact at this time.
So let's have no personal contact. No in-person. That's the best way to do it. No in-person contact. So in other words, I don't want you and she together, but you can have grandma talk to your granny. What do you call your grandmother?
Grandma.
Okay.
My mom.
Have her do a lot of the communicating, and so I don't see that you're a bad guy. That just this is a bad incident.
Yes, sir.
And we don't want it to get beyond. We don't need anything else. So be a good guy, and let's not have this kind of incident in the future. And it's just, if the two of you aren't looking at each other, nothing can happen, right?
Yes, sir.
So you use, even if you have your grandma or someone bring the child to McDonald's and do the exchange, but just don't you do it.
Yes, sir.
Give her time to get another boyfriend. Okay. All right.
I don't want it back.
Okay. Next,
Your Honor.
Thank you.
Also order no weapons, firearms, or ammunition.
Right, no weapons, no guns, no machine guns, no bazookas, no nothing, okay? Okay. Okay, Frederick Thorne. Mr. Thorne?
Yes.
Okay, we do have someone in the audience, so ma'am, if you will stand close to the microphone, speak up. Thank you. Yeah, you can lower it. Yeah, and just speak up. Tell me your name and spell your last name.
Caitlin Cameron, Cameron.
Okay, Miss Cameron. Now, what's your relationship to the gentleman?
That's my husband.
Okay, how long you all been married?
A couple of months, but been together for 9 years.
Okay, lived together 9 years, and you
Lived together for 2 years.
a few years, and you spoiled it by getting married. Okay. All right. Now, has he been violent with you in the past?
No.
And briefly, what happened here?
I think it was a misunderstanding. The plan was to Baker Act him to get some psychiatric help that he does need, not to place any charges. That was not my intentions. So I think it was just a misunderstanding and just acting out of character.
Okay. In terms of violence towards you, what did he do?
There was an incident about a month ago where he was having just a moment and he acted out of character, and because I had his phone to call for his parents for some guidance, and he came up behind me, had his arm around me, and that was not his intentions. It was just to retrieve the phone because obviously he did not want to escalate his feeling any further.
Okay, so, all right. Were you injured?
Not really, no.
Okay. Do you fear him?
No.
Do you think that he could return to the home and y'all can be peaceful and not have any more problems?
Yes.
But you were talking about that he does have some mental health issues, right?
Yes.
All right. Has he seen a doctor? Does he take any medicine for him?
He takes some medicine. He has seen a doctor, and it is in the works of getting him additional help if needed.
Okay, and what, do you feel that that's working, or is it not working?
It's been a slow uphill battle to working.
Okay. All right, because I don't want him to come to the house, because if something happened, we don't want you hurt, and we don't want him hurt. We just want y'all to be peaceful.
Correct.
State your thoughts.
Your Honor, it's alleged within the affidavit that the violent events occurred November 25th, so approximately a month ago, as the victim testified. And at that time, the victim told law enforcement that the defendant pushed and placed her into a headlock, and she felt afraid and did not report the incident at that time, but now feels that the defendant is getting out of control himself. Law enforcement was called to the scene for this incident due to her believing that he was potentially upstairs abusing the cat. I believe law enforcement did do Baker Act qualifications on scene, and he did not qualify to be Baker Acted at that time. However, given that there was a prior incident of violence between the two, law enforcement did arrest Mr. Thorne. I understand the victim's testimony, however, state would still be asking for no contact at this time, Your Honor, due to the potential mental health issues between the two, and given that law enforcement has now been called to the scene at least twice.
Well,
The victim or the defendant also advised that he's currently taking medications, but only takes them when he needs to, which I'm unsure necessarily what that means.
well, do you want to say something?
Yes, so actually, through this whole process, I'll say, yeah, when first, the cops first arrived at our place, yeah, it was also kind of under my intention that I was being Baker Acted, because they asked kind of, if I wanted to go actually down somewhere and talk to a doctor, and I agreed to that term. So I was under that same assumption. But since arriving at this facility, during the initial mental health check, I actually got some good advice from the lady, and she informed me that the one medicine that I was informed that I've been taking kind of as needed, that it needs to be taken constantly, and that was kind of bad advice actually from my doctor.
What's your medicine?
Sertraline. It's for stress and anxiety.
Okay.
It's like Zoloft.
Mm-hmm. You know, there's nothing wrong with taking medicine. I take heart medicine every day because I had a heart attack about 9 years ago. So every morning, brush my teeth, take the medicine, and it's just a routine. And that helps protect my heart from being erratic. And so, you know, so I think that sounds like good advice. You know, by the time you think you need it, let me use my situation. If I'm falling down because my heart is erratic and everything, it's a little late to take the medicine. It's a little late. And so by taking the medicine every day, it keeps the heart sort of smooth. And so do you see what I'm trying to say?
Yes, I do.
And so I want you to just brush your teeth, take your medicine, and just, if you need it, you need it. Mm-hmm. And I agree with the nurse here that as needed is oftentimes too late. So take your medicine every morning. You seem to have a very nice young lady as your spouse, and so just, you know, if you can't get along, just say we can't get along and separate, but no arguing, no fighting, because ma'am, I did domestic violence for 9 years as part of divorce court. And so when the hitting starts, the love is gone. So at this point, you need to be a little sensitive to the idea that maybe the relationship does not have a future for your own protection. And so, you know, you don't hit who you love. you might fuss at them, but you don't hit them. And so, do you understand what I'm saying?
Yes, I do.
So if, so when the hitting starts, the love is pretty much gone. You don't hit what you love. All right. You don't have any real history to speak of. So we'll go ahead and do a $200 bond. No, it's put $200 into the registry of the court, and you can be released. It's to be released with no alcohol or illegal drugs, but also do put in there, Madam Clerk, if you can, but that he is to take his prescribed medicine for mental health, or some words like that. And no hostile contact, because now I've tried to give you the benefit of the doubt, but this ain't going to happen again. Next time, if there's an incident, and so I'm speaking to you since you were the person with the problem, but also, ma'am, another incident, and you're going to not be able to live there. You're going to have to change your whole life in terms of relationship. So you can return to the home for the no hostile contact, no weapons, no firearms, and do you have any questions?
No, I do not.
All right, am I going to see you again?
No, you will not.
All right, thank you very much.
Thank you, Your Honor.
Next, Shamika Walden. Ms. Walden? Okay, Ms. Walden, this is conspiracy to commit battery. And State, do you want to talk about that a little bit?
Your Honor, it solely came in as a battery.
So it's just a battery?
Yes.
Okay. Speaking with just a battery, victim contact was attempted. We don't have anybody in the audience. Do you and the other person live together?
No,
Were you just friends?
my boyfriend.
Say again?
Boyfriend.
A boyfriend?
Yes.
Your Honor, may this one be reset to tomorrow? I believe state may file different charges, as this arguably is a burg bat, which is a PBL.
Your Honor, I would object. It came in as the conspiracy to commit a battery, which really the officer put in the arrest affidavit, just battery. I don't think it's appropriate to give the state 24 hours to file additional charges. If they would like to add additional charges later, they can always do that. But to hold her here for an additional 24 hours for them to add charges, I would object, Your Honor. Usually we give 24 hours if there was no PC found, but here you found PC for the battery.
Your Honor, the allegations within the affidavit are incredibly troubling. It's alleged that the defendant entered the residence through a garage that she had no right to be at, entered, immediately started punching the victim in the face. When asked how she got in the house and to leave, she began to pull the hair of the victim and continued to punch him, and then started to push the victim towards the door by her arms to get her out of the house. And they eventually both fell on the floor. She entered the house unannounced through the garage. She, I believe, entered a code. However, she had no right to be in that location. So arguably it is a burg dwelling with a battery or assault therein.
Right.
It is a PBL. I understand she has little to no history, and the officer currently charged it as an M1. However, if Your Honor is uninclined to give state 24 hours to amend the affidavit, state would ask for a much higher bond than the court is most likely going to set on an M1, given that allegations in this affidavit are incredibly troublesome to both the victim and the witness that were present in this household.
Your Honor, we have plenty of cases that come in where the officer...
Can you speak into the microphone?
We have plenty of cases that come in where the officer doesn't charge additional charges where he can. I would just ask that you set a reasonable bond, given she has no criminal history here. But I am objecting to an additional 24 hours so the state could add additional charges. They add additional charges later on down the line in many of cases, but to hold my client here for another 24 hours for them to do that, I would object, Your Honor.
Your Honor, under the rules of criminal procedure, state has 48 hours to establish PC. We generally do it within 24 because they must be seen within 24. However, state generally has 48 to establish probable cause. Therefore, we'll be still well within our 48 hours.
But Your Honor, found probable cause to the battery. You're asking for 24 hours to add additional charges, not that there is no PC, Your Honor.
Right, the rule, as I understand it, is only that I'm only allowed to extend it for PC, and not for additional charges. Well, I'm sympathetic to what you're saying is logical, but I don't think it's within the rules, and so I have to follow the law.
They would just ask for a much higher bond then, Your Honor.
And so, yeah, I can see where, when I read this originally, when I first got here, I see what you're talking about it could be a burglary, it could be a bunch of other things. So I don't think this is going to go away. So we'll go ahead and do it as a $1,000 bond. No return to the premises, no contact with the victim, no alcohol or illegal drugs, and anything else, any special other conditions, state?
Your Honors, they would also ask for no contact with the witness,
Right,
as
no
well as no
contact.
weapons, firearms, or ammunition.
Right, no contact with the victim or any witnesses, and no firearms or ammunition. Okay, thank you very much. Next is Jerome White. Jerome White, Mr. White.
Yes, sir. How you doing?
Okay, this is domestic battery. Mr. White doesn't appear to have any, well, he does have a Florida aggravated assault, a weapon and a robbery.
Sir?
In Florida somewhere. And then we have this, I do see here, he is on carjacking with a firearm, robbery with a firearm. So for an unbelievable reason, surety bond and ROR. I just saw the ROR. I was thinking, ROR for that? But the surety bond, everything is revoked, is put as a zero bond at this time. So, and then, it just says here the victim is not interested in coming to court. And this is so, so we'll go ahead and, as far as this is charged as a misdemeanor, so we'll do a $1,000 bond. And no bond on the other, as already said. No contact with the victim, no firearms or ammunition, no illegal drugs or alcohol, and just I want to check one more thing.
Are we appointed on the out on bond, Madam Clerk? Can you see?
I'm sorry, I didn't hear you.
We are?
Yeah.
I was asking if we were appointed on the out on bond since it's held at no bond. I can't find it
Right.
in our system.
We'll appoint the public defender for the revocation and all.
Oh, he has private counsel?
Yeah,
Okay,
you're already on it?
He has private counsel, so I would not
Oh, he
ask.
has private counsel?
Yes, Your Honor.
Okay, who is the counsel? Olinsky, Matthew Olinsky? Yes, sir.
I go to court January 3rd for that charge. It's supposed to be getting dropped because they don't have any evidence on me.
Okay.
Yes, sir. That's
Okay.
what I was going to tell you. And then also, like, what I'm here for the battery.
Don't talk about the facts.
Okay, so we do have boyfriend, girl. Do y'all live together?
Yes, sir, we were living together. Like, we recently got into an argument, so I left. I was just going to see my baby for Christmas. She wouldn't let me see the baby. Like, I've been trying to get in touch with the court so I can get visitation rights. So, like, I was talking to her today, this morning. She was like, I can come see my child. But I got in the midst, like, with work and stuff, so I didn't come right away. I came later on. Like in the affidavit, it says she gave me a spare key, which she never asked for back. So I used the spare key to get
Okay, that's okay. That's fine. You know, in divorce court, we hated Christmas because that was our most active time. So beginning December 1st, all the way through December, we had, she won't let me see the kids. It just drove us crazy. And so,
I would just
anyway, so at this point, you've got enough problems. You're to live separate and apart, no contact with the victim, no contact with the victim. We'll go ahead and so then we'll go ahead and do the $1,000 bond, and that he can return to the premises with the sheriff or with law enforcement to get his clothing and personal items. And did I say no weapons and firearm?
Yes, sir, you said no weapons.
Okay, all right, thank you.
Your Honor,
Okay,
They
folks.
would also ask for no contact with a witness, as there was a witness, as well as to comply with DCF, as the child was present and DCF
Right,
was
so
notified.
no contact with the victim and any witnesses. Okay, folks,
Your
thank
Honor,
you.
what do they mean by the contact with DCF? What does that mean? My child gonna get taken from me?
No, just that if they get involved, then you need to cooperate with them.
Yes,
That's
sir.
all.
So will I be able to bond out and go back home, or?
No, you can bond out and just go live somewhere else.
No, I'm saying not go back home to her. I'm saying go back home to my mom or something. Like,
Oh, yes.
I would be able to bond
Your
out
bonds
tonight.
revoked on your last case, so you won't be able to get out.
To call your private attorney.
My bond got revoked.
Yeah.
All right.
Okay. Well, you're going to be seeing the court 1st of January anyway, so it's not going to be long. Okay, let's see. Marvina Winden, Miss Winden? Okay, this is a domestic battery, out-of-state incidents, none, and looks like no combat. Let's see, honorable discharge. Let's see. So you were in the military?
Yes,
Which branch?
Army.
Army, very good. Okay, so you and the victim live in the same household?
Yes,
Do y'all have a child together?
yes.
Okay. Where's the child now?
She's with him.
With him?
Yes,
Okay. Boyfriend?
yes.
Okay. Have there been any other prior incidents prior to this one?
Yes, I actually just dropped an injunction on him Wednesday.
Okay. Well, he does say a victim does not want to have contact, in other words, personal adult contact, but other than regarding shared parenting. You need to probably go back to injunction court and file your petition, because injunction court or domestic court is a lot slower, but injunction court is a lot quicker, and they can figure out where the child should be, either with you or with him. So at this point, my job is not to determine parenting. but I'll go ahead and state that the parties are to not live together, that she can get her stuff. As far as, what'd you do in the Army?
I was an information technologist, if it makes sense. So just really with technology.
Oh, very good. What discharge do you have?
Honorable.
Honorable?
Mhm.
Okay. Yeah, I was in the Air Force for 6 years, and I was in military police and in corrections. So I ran a small Air Force prison, and I was the police chief of the base. I tell you, you don't have any history, and you understand that this is not acceptable. You understand? And it's just going to get you in a lot of trouble. So I'll go ahead and make your bond $100. So you post $100, and you can have contact. You can't live with the victim. I think maybe that period's over with, but you can have contact as relates to the child, but no contact except in public. In other words, y'all meet in the food court of Walmart or something. You meet where there's a bunch of people around. That's for your safety and his. So there's always cameras. Also, there's lots of cameras. I love cameras because we see who does what to whom. And so if you're going to meet with anybody, you meet in public where there's a bunch of cameras and no hostile contact, and y'all can figure it out.
Your Honor.
Yes.
Respectfully, state objects to a $100 bond, and there were videos that the victim turned over that corroborated his story. It's alleged that the victim stole his phone, ran away. The defendant or the victim tried to get his phone back, and she began hitting him and pulling on his dreads. And DCF was notified of the incident. However, given under Florida statutes, this court cannot order a no hostile without the victim's testimony that he would like contact with her. So
All
state
right,
would just ask for a no contact and then comply with DCF. And DCF can put a parenting plan in place to allow them to have contact regarding the child. However, under Florida statutes, since he's not here to testify, this court cannot put in place a no hostile.
All right, I'm going to leave it like it is. So no more stupid stuff, you understand?
Yes.
And I did $100 because this is stupid stuff. And no stupid stuff, and do it right from now on. You understand?
Yes.
What rank were you?
Well, when I got out, I was like an E4.
You were an E4?
Yeah.
So to get an E4, what were you, 2 years or something?
Yeah, I was only in there 2 years, and then I got hurt.
Yeah. But if you got to be an E4, then that tells me that you're intelligent and you know how to follow orders and you know how to, in other words, you know how to do things right.
Yes, I do.
So let's do things right, E4, okay?
Okay, thank you.
All right, thank you. Have a nice day. Next, okay, Cody Faust.
Yes, sir.
All right, Mr. Faust, this is violation of probation. It's a $10,000 bond. It is this a warrant? Yeah, it is. And so you'll go to VOP court. So we're not going to do anything today. VOP court will be in 2 or 3 days. Your lawyer can tell you more about it. All right, folks, thank you. All right, do we have afternoon?
Okay. We have 33-day motions still.
Thank you.
Did you want to do a denial on this deal? I thought if it had a bond.
He has a bond.
All right, ma'am, I do appoint the public defender, and you have possession of heroin. You're arrested for possession of heroin, cocaine, controlled substance, paraphernalia. And And you do have some other charges that are past history, I mean. And so we'll go ahead and the recommended bonds as is, Madam Clerk, $1,000 on the heroin, $150 cocaine, and then controlled substance the same, and then paraphernalia $100.
The only condition, Your Honor, on drug cases that the state recommends is no drugs or alcohol without a valid prescription.
No drugs or alcohol without a valid prescription. Thank you. Next. Next, we have Office of the Public Defender. This is arraignment. No, we don't have other paperwork. We just have this paperwork. All right, the clerk tells me we have an arraignment here. And it's a Matthew John Armstrong.
Medical, Your Honor.
Medical. All right, so we'll go ahead and put that he is to be brought to initial appearances within 24 hours of being transferred from.
Your Honor, I will waive the appearance and enter a plea of not guilty.
All right, and.
For Division 82, pretrial conference will be January 31st, 10:30 a.m., courtroom 10B.
And this is a second-degree misdemeanor. So, Madam State, are you okay with the 250? Second-degree misdemeanor or something different?
Your Honor, whatever's on it, we usually stay. We don't change it.
Okay, I don't see a number.
Yeah, he already has a bond of 500 on that case, Your Honor, so it will just stay.
Bond of 500, pretrial release tells me. Okay, then we have Anthony Suarez Diaz. Okay, and that is you, sir?
Good morning, Your Honor. Yes, sir.
Good afternoon. And this is a petty theft, $100 or more. This is an arraignment. So do you, public defender, do you wish to plea? And
Yes,
state, is there an offer?
Yes, Your Honor, state did convey an offer to Mr. Suarez Diaz of an adjudication of guilt, credit time served, no return to the Home Depot located at 13121 South Orange Blossom Trail, and restitution to Home Depot in the amount of $229.
2023.
And that,
229, yes, Madam Clerk.
and then we have court cost and public defender. Is there a nominal fee for your office?
Yes, Your Honor.
Yes, Your Honor.
What is that?
$50 public defender fee.
Okay, $50 public defender fee. Sir, do you agree to that?
Yes, Your Honor.
Okay. All right, we'll total that and send it to collections court. We'll set up a payment plan of $20 a month.
Your Honor, has he been sworn to accept the plea?
I'm sorry, I didn't.
Has he been sworn in to accept the plea or the plea colloquy?
No.
You just want to tell the truth, whole truth, nothing but the truth, so help you God?
Yes, I do.
All right, everything we've said is okay?
Yes, Your Honor, sir.
Okay. All right, and then we'll do the $20 a month. So you owe some money because of this process, and I want you to pay $20 a month beginning. Do you have a job?
Your Honor, I've been in the Department of Correction for the past 39 months, and I've had these detainers for like about 36 of those months, and I wasn't able to go to work release because of the detainers. But even so, I have Social Security, mental health, disability benefits.
Okay, I'll tell you what we'll do. We'll reduce that to a judgment.
Thank you, Your Honor.
Okay, thank you, sir. Okay, next we have Darrell Lindsay. Darrell, D-A-R-R-O-L, Lindsay. All right,
Is that a
Mr.
plea of no contest? Because he never said.
Yeah, no contest, please.
And how many days credit time served? Okay.
I'm gonna argue, just give me a second.
That's why I have. That's the day.
Are we ready?
Yes, Your Honor, we're ready. For Mr. Lindsey Darrow, the state was not making an offer on his case, his trespass. However, I would ask for an ROR since the state is not asking for, is not making an offer, Your Honor. My client is currently, the only way that he's able to be transported back and forth for work and other things like that is through the bus. He pled to a trespass from the Lenox bus station. And usually when he pleads to those, we ask that he does not return unless he has a valid ticket. And he's coming back and forth to work and he keeps getting arrested. The Lenox bus station saying he's trespassed, and my client, that's his only means of getting to and from work.
Yeah, I don't, that's a real conundrum or meaning a real problem for people that have to take, who have to take public transportation is, it seems like they should not be allowed to trespass people unless, if they're disturbing, arrest them or run them off. But trespassing, it just doesn't make any sense.
Yes.
Because I totally accept what you're saying. It makes total sense. He can't hitchhike. He can't really walk at his age. I think you're younger than me. How old are you?
I'm 63, Your Honor.
60? Oh, you're just a kid. Just a kid. So even though he's just a kid, walking is not reasonable. So it's just, I would ask the public defender's office to go before whoever runs I know there's some committee or something that runs the bus system, and talk about this. If someone's disturbing something, have them leave. Tell them you have to leave.
That's often the problem, and that's why they get trespassed. They then don't.
Otherwise, how do poor people get to work? I've always sort of thought, I wish the mayor and the city council and the county commission would have to take public transportation. Then it might be actually good.
Yes.
But they have a limo or something, I don't know what they do. So I guess, but this is a misdemeanor, and this state would have to make an offer, but I don't think I could just go ahead and tell you what I would do. Is that correct? Procedurally, I want to follow the procedure. Yes. So unless the state agrees to make an offer, then I can't do anything.
Yes, you can, Your Honor.
I can.
We could plead to the bench as well, Your Honor.
Okay.
I just did not know if you would be willing to accept an offer here today.
Yeah. All right. So we'll go ahead and I would go ahead and accept $100 fine, court cost, public defender fee, reduce it to a judgment, and give them time served.
Okay. He would like to accept that offer, Your Honor, and enter plea of no contest.
And yes, would.
Your Honor, he needs to be sworn in and the plea colloquy gone through.
Yes, thank you, State. Thank
Do
you.
you swear to tell the truth, whole truth, nothing but the truth, so help you God?
Yes, ma'am.
So that's adjudication and guilt with 2 days of time served?
Yes, time served, whatever it is.
Or is he going through the plea colloquy? No.
Your Honor, Mr. Lindsay, would like to enter a plea of no contest. He understands all the rights who would be given up, and he would like to accept the offer of an adjudication credit time served.
All right, thank you very much. Okay, next we have Jesus Antonio. Mr. Antonio?
Yes, Your Honor.
Okay, this is a petty theft, and, okay, let me. Okay, State, is there an offer here?
Marquez. Misdemeanor pleadable.
So we skipped. No, Your Honor, they're not gonna make an offer because the petty theft is enhanceable.
Okay, defense, your thoughts?
No argument, Your Honor. It's normal. When it's enhanceable, they usually don't make an offer.
Okay, all right, and then we'll leave it as the 250 for petty theft and 250 for the trespassings on a conveyance.
They would ask for a no return and no contact with victims or witnesses.
All right, no return. And I'm sorry, it was no return and something else?
And no contact with victims or witnesses.
No contact with victim, yes. Thank you.
Your Honor, may I approach with the restitution order from the
Oh,
previous
yes,
case?
ma'am. Thank you. Okay, and this is Valerie Wright.
Mental health, Your Honor.
Mental health. All right, this is a criminal mischief, $500 bond. Are we okay with just setting the bond and plead not, it's not arraignment?
Yes,
It's
Your
just
Honor, I'll waive the
$500
appearance.
bond, no return, no contact. Okay, now we have misdemeanor, it says non-pleables. Okay, this is failure of defendant to, okay, this is he failed to appear for arraignment, and this is Lewis Charles. Lewis Charles, are you Mr. Charles?
Sir.
Okay, Mr. Charles, you failed to appear for arraignment. The bond is $2,000. Okay, thank you.
Did Karambot, Delgado, and Rosado both bond?
What's the booking number?
The paraphernalia people?
Spanish. They're Spanish.
Okay, never mind.
Okay, are we together on Nicholas Brown?
Yes, Your Honor.
Okay, Mr. Brown.
Yes, sir.
Okay, this is soliciting without a permit, roadway solicitation, offer from the state.
Yes, Your Honor, as this is a city case, it's a county case, the state would be offering a adjudication credit time served.
Your Honor, we can't take the state's offer. My client just recently had his competency evaluation done. There's competency concerns. So I would just ask that you consider setting a $50 bond on counts 1 and 2 and taking no action on the trespass. I believe it was just panhandling.
All right, and the reason for the $50 bond, as opposed to the offer, is so that he can receive services?
Yes, Your Honor, there's comp concerns. We believe he has multiple Baker Acts, so we're trying to get him the necessary help.
Right, all right, and Yeah, we're going to sort of keep hold of you for a little bit so we can help you with your medicine and get diagnosed as to what is the right medicine and get you on your medicine. Is there some way this gentleman who can get medicine and when he's not in the system, does the public defender have that? Figure that out?
Yes, we have services that we'll be able to help him with once we have the doctor's evaluation listed in the.
All right. We'll go ahead and do you don't have $50 or $500 is the same thing.
Yes, that's fine, Your Honor.
And so $50 on the each count. And then no return to, I forget what place this was. No return to the premises and no contact to the people. I think, is this the one that was the gas station?
No, Your Honor.
Okay, one of those.
And no action on his out on bond, Your Honor?
Say again?
No action on the out on bond?
Oh, no action. No action on that. Okay, next we have Apache Hunt. Are you Mr. Hunt?
Yes, sir.
All right, Mr. Hunt. This is alcohol beverage, open container.
Your Honor, the state did convey an offer on behalf of the city of a withhold credit time served.
All right, time served. Do you accept time served?
Your Honor, he needs to be sworn and the plea colloquy needs to be gone through.
Yes.
Raise your right hand. Do you swear to tell the truth, whole truth, nothing but the truth, help you God?
Yes, ma'am.
All right, time served, court costs, we'll reduce it to a judgment. Is that acceptable?
Yes, sir.
All right,
Your Honor, is it a plea of no contest or a plea of guilty?
No contest.
no contact. Do not go back to the premises. Okay, thank you. Okay, I have next, it's bonded, it says, it's a traffic thing, and let's see, where is the defendant's name? Powers, is that Megan Powers is bonded out? Is everybody's?
What's the booking number?
Can you, I don't know where that booking number is.
2102-9823.
Yes, she bonded.
Okay, next we have felonies. And so it would be Mr. Ribnico Choice.
Yes, sir.
Okay, Mr. Choice, you have charges of possession of cocaine with intent to sell, sale and delivery of cocaine, drug equipment, possession, neglect of a child, possession of controlled substance, possession of fentanyl, moving traffic violation, driving while license suspended, revocation. And so there are bonds already set at $15,000.
Your Honor, state and defense are both in agreement that there is not PC as to count 2. So we'd be asking for an ROR as to count 2, the sale and delivery of cocaine.
Sale and delivery of cocaine, ROR you're suggesting?
Yes, Your Honor.
Okay,
asking
all
that
right,
you
we'll
pay
strike the
rest of the bonds.
15,000 and put ROR there by agreement of the state, or recommendation of the state. Everything else the same?
Yes, Your Honor, state would ask that you stay everything
Okay,
else.
all right, then the 15 is the first one, ROR is the second one, 1,000, 5,000, 3,500, 5, and then 5,000, and then 500. Did I screw that up too badly? Okay. All right. Okay, sir, thank you.
Your Honor, state would ask for the conditions of no drugs or alcohol without a valid prescription, no contact with victims or witnesses, no weapons, firearms, or ammunition.
All right, agreed.
Your Honor, I would ask that you consider reducing at least some of these and treat them as subsidiaries, at least the paraphernalia and the driving while license suspended. I understand the neglect of a child is usually set higher than the other charges. However, I would ask that you consider treating some of the charges as subsidiaries of $150 bonds.
State.
Your Honor, on the paraphernalia, which is count 3, that usually comes in at $500 bond. State has no objection to be treated as so. And in regards to counsel's argument as to count 7, as to the Julissa, state has no objection to that being down to 100.
Did you get that? No, we had a hard time.
100 on 7 and 500 on 3.
Okay, we're good. Granted. Okay, next is, let's see, Johnson, Dewell, Dewell Johnson. Mr. Johnson, this is burglary of a dwelling, $5,000 is the recommended bond. The meth is 150, possession of meth, 150, possession of Xanax, 150, criminal mischief, 100, resisting an officer without, 100. That all seems reasonable, and so that's what I'd order. And defense, are you okay?
Yes, Your Honor.
All right.
Your Honor, state would ask for the condition of no contact with victims or witnesses, no return to the scene, no weapons, firearms, or ammunition, and no drugs or alcohol without a valid prescription.
Your bond.
Granted. Okay, next is Miguel Martinez Lorenzo.
Medical, Your Honor.
Okay, medical. Defense, are you okay with these bonds?
Yes, Your Honor, I'll waive the appearance.
Okay. Driving is 2,500. Possession of a firearm, 5,000. Possession of ammunition, 150. Possession of cocaine, 150.
Your Honor, state would ask for the conditions of no weapons, firearms, or ammunition, and no drugs or alcohol without a valid prescription.
Granted. Next, we have Stephen Rodriguez.
Yes, sir.
Mr. Rodriguez?
Yes, sir.
This is possession of cocaine. $1,000 is a recommended bond. Introduction of contraband into the facility here, 1,000. And then there is an out-of-state warrant from Polk County with a 0 bond. So really, so we're going to notify Polk County?
Yes, Your Honor.
Okay. And so, all right. And so at this point, state,
Your Honor, on the cocaine and contraband, the 16184 case, they would ask for no drugs or alcohol without a valid prescription and no weapons, firearms, or ammunition.
granted. Now, the last one I have, now is this a drum, do we get a drum roll here?
We still have Spanish after him.
Okay, all right, we have Gary Wilson, Mr. Wilson. This is burglary of a dwelling with an assault or battery therein, and I believe that's an F2.
No, Your Honor, it's a first-degree felony that's punishable by life, so state's asking that you stay the no bond so he can have an Arthur hearing downtown at a later time.
Okay, all right, then that's a no bond in this court, with the right of the defendant to have an Alford hearing at a later time.
Your Honor, state would ask for the conditions of a no return, no contact with victims or witnesses, and no weapons, firearms, or ammunition.
Granted. Okay. Aram, but Telago, something.
Good afternoon. This is Dalia Romero, Spanish interpreter on the line. Already sworn in today, Your Honor.
All right, thank you very much. And, sir, do you need or would you prefer an interpreter?
Yes.
Okay, all right, and how do you say your last name?
Drachir Karambot.
Rachi Karambo.
And Drachir, D-R-A-C-H-I-R, is your first name?
Yes.
Yes.
Okay. All right, sir, you're charged with possession of drug paraphernalia, and that is a misdemeanor. And let me ask the state, this is a misdemeanor.
Yes, Your Honor.
Do you wish to make an offer, or is there a reason that we shouldn't?
State is going to announce a no info, Your Honor.
I couldn't understand.
State is going to announce a no information.
State is gonna, no information on this case. State
Oh,
not gonna-
okay. The state's going to announce a no information, which means that they're not going to charge you in this incident, which means that you will be released later today.
Yes.
All right, thank you. Okay, next is Juan Rosado. Mr. Rosado, you are charged with possession of
Sorry,
drug
Your Honor, does he need an
paraphernalia.
interpreter? Does he need the interpreter services?
Yes.
All right, do you need or would you prefer interpreter services? Yes, see?
Yes.
Okay,
I need an interpreter.
yes. That's totally fine. My wife speaks American French, but when we've gone to France, we always use an interpreter. And because, you're not comfortable with the language, so it works. Sir, you're charged with possession of drug paraphernalia. State, or do you wish to proceed on this? I see a note here, out on bond, trespass. And so there's trespass, a misdemeanor. It looks to be in this county, Division 82. Your thoughts, State?
One second, Your Honor. Your Honor, state's also going to announce a no information from Mr. Rosado.
All right, as far as this new case goes, the state will offer no pros, or no information, I meant to say.
And in regards to his animal trespass, state's asking for no action.
And then we will take no action on the case that he's out on, the misdemeanor case. So that's all the business we have today.
Gracias. Thank you.
Okay, next we have Julian Castaneda, bonded. Then we have Arnaldo Luis Cruzavilla, correct? Oh, bonded also? Okay, so this is bonded also. But we need to just take just a second up here. Are we good? I'm good. All right, she's ahead of me. Now we have Mauricio Gomez Lopez, is that you? All right, we're happy to use the interpreter. And so unless you tell me you don't want it, then we'll go forward. You're charged with a battery on a medic?
Uniform licensed security officer.
Oh, security, okay. And this is a felony. And State, can you sort of help me here?
Yes, Your Honor, it's an F3. It is alleged that the defendant got into a physical fight with the security officer.
Is this a private security
Company?
person?
Yes, Your Honor.
I notice here, out of state, none, Florida, none. Is the fact that it's a felony, is it more of a battery? If it wasn't for uniform medic or security officer, would this be a misdemeanor battery?
Aggravating factors, Your Honor, yes. Or that's why the legislator makes the aggravating factors higher degree felonies.
Okay, I can't understand you.
But for a licensed, uniformed, on-duty security officer, but for that, arguably the other thing that would have been filed is a normal battery.
Right, that's what I thought.
However, it is an aggravating factor that he was a licensed security officer.
Mm-hmm.
It's also an aggravating factor that the defendant has no community ties here, is not a citizen in the U.S.
Right.
State's asking that you stay the box is currently set.
Well, the fact that
25. Your Honor, it's alleged that the defendant had the victim pinned against the wall. While he had him pinned against the wall, he was repeatedly striking the victim. Law enforcement arrived and was able to pull the defendant off the victim.
okay. How long have you been in the United States?
It was 6 meses.
6 months.
Okay. All right. All right, there's really no mitigating circumstances, and there's several aggravating circumstances. So we'll leave the bond as is at $2,500. Okay, thank you very much.
Your Honor, state would ask for the condition of a no return, no contact with witnesses, as well as no weapons, firearms, or ammunition.
Yes. Granted. Okay, thank you. Well, I want to thank everybody. I think we got through this and we all survived. And so, thank you very much, everybody.
Thank you, Your Honor.
And so, how do we turn all of this off? It's off, okay.